Good afternoon. Sorry for the brief delay in connecting with everyone. Um, so I have, interestingly enough, um, a number of emergency matters that were all sort of put on the calendar one after the other for today. So they're in a rough order. Starting with Throttlebox Entertainment versus Blair Richardson. Mr. Freehoff, I don't know if you can see who's trying to log in by Microsoft Teams, but if you could message that person and let them know to use the Zoom link and not Microsoft Teams. Do I have, who do I have here on behalf of Throttlebox Entertainment?
Good afternoon, Your Honor. Chris Brown on behalf of Throttlebox, and here with me is Attorney David Wolf, who is also the witness who signed the verified complaint to testify today. And
Okay,
that's all.
Thank you very much. And then I see that I have Blair Richardson. Ms. Richardson, do you have counsel representing you in this matter?
No, ma'am. No, Your Honor. I'm appearing specifically today, not generally, and only for the limited purpose of objecting to this hearing, and I don't have counsel.
Understood. And I'll go into that in just a moment. Before I do you have a court reporter? Has anybody retained a court reporter that is taking this down so I can call the case and get them started?
Thank you, Your Honor. We have retained, and we would ask that the court inquire about sharing takedown, and if they don't wish to share takedown, that the court issue an order that only the plaintiffs will have access to the transcript before the hearing begins.
Okay. Ms. Richardson, that I'll put it on the record in a moment, but right now, just generally, the request that was made by Ms. Brown was that the court reporter, who I assume is that Reed Hicks, are you my court reporter? Okay. She's going to take down this hearing, however long or short it may be, Ms. Richardson. And part of that will be your opportunity to formally put an objection on the record. Excuse me. But there's a cost involved in having her take down the transcript, and typically that cost is shared by the parties. And so the question that's been asked by Ms. Brown is whether or not you wish to share in the takedown cost. And if you do not wish to share in the takedown cost, then Ms. Brown has asked that I limit the transcript availability to only the people who paid for its takedown. Do you understand that request, Ms. Richardson?
Yes, Your Honor.
Okay. Do you have an answer for that as you sit now? As I said, I'm going to make a record of all this in just a moment. I just want to make sure we're all on the same page before we start.
I would prefer not to pay for it.
Understood. Okay, fair enough. So just in case for those of you that are involved in this hearing, the two individuals just walked in my office are interns. They're rising second-year law students, Isabel Rogers and James Robertson, who will be observing. So just show them some good lawyering when we can. And now, madam, we will go ahead and go on the record for the court reporter. This is going to be an emergency hearing in the matter of Throttlebox Entertainment, LLC versus Blair Richardson. Case number 25 CV 007060. I'll note for the record that I have Chris Brown here on behalf of the plaintiff Throttlebox Entertainment, and that she has with her a person that signed the verified complaint and that is available as a witness should that be necessary, and that is Attorney David Wolf. And I also have present Blair Richardson, who is the named defendant. And in a moment, Ms. Richardson, I'm going to let you put any objection that you might have to the proceeding. At this time, Ms. Richardson has indicated she does not have counsel. I'll also note that this is a case of very recent origin. It was filed on May the 22nd and immediately Throttlebox reached out and requested an emergency hearing for the possibility of temporary and or long-term emergency relief. The reason I mention that is just to make sure everybody knows our process when that request is made in Fulton County is that we require that you reach out to the opposing party and do anything you can to make sure they're aware of it. Ms. Brown, are you ready to proceed on behalf of Throttlebox for the emergency relief that you've requested?
I am, Your Honor. And before I do, though, and I know Your Honor has acknowledged that Ms. Richardson is not sharing in the takedown, but there is a case, I think it's Davenport versus Davenport, that requires me to ask for an affirmative discussion on the court and acknowledgement from the defendant that she doesn't wish to share and take down, and then the court's order that only I would have or the plaintiff would have access to the transcript, and the case establishes that that would have to be put on before the hearing begins. So even though we sort of talked about that before we went on the record, I would ask that the court sort of revisit that issue and establish that only the plaintiff would have access because Ms. Richardson, who I hope will affirmatively state what she previously indicated for the record.
Okay. And I'm going to call on her to do that in a moment. I'm happy to put that on the record, Ms. Brown. I think you're right. I will say, I think that from a lot of those cases are targeted at situations where it is the court's reporter that is taking it down. And that's not, I mean, we have a private reporter here who I've never known a private reporter ever to voluntarily file a transcript or provide it to a party who has not paid for it. But you're not wrong in your request. And so I don't mind advising the court reporter that to the extent that there is any question that you would provide the transcript, an official version or unofficial version of that transcript to anyone other than the court and or the party who paid for it. In this case, Throttlebox Entertainment, that I am prohibiting you from doing so unless and until any other party pays for their share of the takedown. Does that satisfy your concern, Ms. Brown?
There's one more, Your Honor. The case that I'm referring to, and I actually did have this happen with a private reporter in DeKalb County.
Interesting.
Is that the court would ask the defendant on the record if she wants to share and take down, and then advise her that if she does, and then she would affirmatively say she doesn't want to share, and then the court would establish what you just did about not having access. But that colloquy, if you will, has to happen on the record, according to this problem I had in another court.
Fair enough, Ms. Brown. I'm always happy to get advice to make sure that I don't get reversed on something relatively minor. That's perfectly fine. Ms. Richardson, to Ms. Brown's point, as before we went on the record, we discussed the fact that Throttlebox is paying the court reporter to be here and will pay a fee for them to take down this transcript for this hearing, however long or short it may be. Ms. Brown has indicated that they believe they're entitled to an order that prohibits the court reporter from paying you, or excuse me, from providing you with a copy of the transcript unless and until you pay your share of the takedown. And before we went on the record, you indicated that you were at this time not inclined to participate in the cost of the takedown of this hearing. Is that correct, Ms. Richardson?
Yes, Your Honor. And I was just wondering if I could make a request as well.
You can. Let me just ask you one other question. You understand that as I just said a moment ago, if you do not participate in the takedown, unless and until you participate in the takedown, you would not be entitled to obtain a copy of this transcript from the court reporter. Do you understand that?
Yes, Your Honor.
Okay. So now I called on Ms. Brown to ask if she was ready to proceed with this hearing. So now I'm going to ask you the same question, Ms. Richardson. Are you ready to proceed with this hearing on your own, as you've indicated to me that you do not have counsel this time?
Yes, I would love to make a request, though, if that's possible.
Yes, ma'am.
I would respectfully like to ask that this hearing be postponed because I have yet to be properly served and I haven't been given time to get a Georgia attorney. I was given an email that I didn't consent to over the weekend. I'm not even in the state, haven't been for a while. And I would just like to humbly request a continuance if that's possible.
Okay. Ms. Brown, what is your response to that request for a continuance? And I will just, for Ms. Richardson's benefit, reiterate that she has indicated she is appearing specially and not generally submitting herself to the jurisdiction of the court, which she stated before we went on record. Ms. Brown.
Understood. Thank you, Your Honor. And I appreciate your indulging me with the transcript issue. Before we get into that, and we object to the request, and I'll explain why in just a moment, but there's something else that I want to disclose in terms of representation of Ms. Richardson. I do want to ask, because there are some other people who I don't know who are on the Zoom, and I don't know if they're testifying related to the case. I don't recognize Ms. Conta or Mr. Ms. Conta.
Forgive me for interrupting. I can save you some trouble. Mr. Alexander and Ms. Conta are here for the second hearing that I will have after this one. Mr. Robertson is the intern I mentioned a moment ago, but I do not know who Jolanda Boone Campbell, the person identified as Tenon and the person identified as iPhone, who those people are. Are any of you here for the Throttlebox Entertainment versus Blair Richardson matter?
Your Honor, this
yes,
is
ma'am.
Jolanda Boone Campbell. I am here for Ms. Conte.
Okay, thank you, ma'am. If you'll just remute and continue to be patient. Thank you. Mr. Freehoff, if you will remove iPhone or Tenon, whoever that person is. Sir, were you unmuted? Are you here for the Throttlebox versus Blair Richardson matter? Mr. Freehoff, if you will please remove Tenon and iPhone 4 to a breakout room and inquire with them if they are, what matter they're here for. Thank you. Ms. Brown, please continue.
Thank you, Your Honor. And so with that, we'll invoke the rule of sequestration. The other thing I wanted to confirm is that I believe the court standing order of Fulton County, as well as your individual case management order, says that these proceedings are not to be recorded by any party. It's only the official court reporter proceeding. Is my understanding correct?
You are correct. Now, in full disclosure, this matter is being live streamed onto YouTube, and there is, as a function of YouTube, a recording made that is, I'm the only person that has access to it. But I will say a couple of things. One, it is marked when it lists as a live stream. It says do not record on it. It is not an official court record. It may not be relied on for any reason. You do not have permission to record. And again, it is not an official court record of any type. So just a reminder of that for anyone's benefit. Now,
excuse me, Your Honor.
Yes, sir, Mr. Alexander.
I apologize. I couldn't find my button so I could speak. iPhone is one of my witnesses.
Okay, that's fine. Thank you, Mr. Alexander, for letting me know. Just to be clear, a couple of things to Ms. Brown's point. Number one, anyone that is here who hasn't already identified themselves, although I think they have, it appears everyone here is for the other matter in terms of witnesses, with the exception of Mr. Wolf and Ms. Richardson. And just to let everyone know, the rule of sequestration has been invoked, and that means that if anyone is here who anticipates that they may be called to testify in the matter of Throttlebox versus Blair Richardson, the rule has been invoked and you are prohibited from remaining in the room unless you are a party. If you'll identify yourselves, Mr. Freehoff will place you in a breakout room and we will invite you back in to testify at the appropriate time. The second issue, Ms. Brown, I want to go back a moment ago. I understand you said you objected to Ms. Richardson's request for continuance. If you could just address that issue in terms of your formal basis for your objection.
Thank you, Your Honor. And first, I want to disclose something with regard to an attorney in California who reached out to me yesterday on Ms. Richardson's behalf, who I understand just moments before we started today has said something directly to the court. And I'm not certain the court would have seen or received that prior to today. So I want to at least, or prior to starting the hearing. So I want to at least just disclose that from an ethical standpoint. And it speaks to what Ms. Richardson was talking about today with the personal service. However, with regard to my objection, and that lawyer, by the way, is not licensed to practice in Georgia, and therefore he didn't make an appearance this morning. But related to the objection, they have acknowledged now, both by her counsel in California as of yesterday's call to me, and by Ms. Richardson this morning, and by correspondence from counsel, that as of Friday morning, she received actual notice of this morning's hearing. Now, importantly, the scope of this morning's hearing is not the merits of the case. It is the interlocutory injunction and emergency restraining order request that we are asking for, specifically under OCGA 9-11-65, specifically B, the temporary restraining order that is allowed to be granted without any notice. So I don't think that given those parameters and the scope of what we're asking for this morning, that service of process, if you will, is required on her. I think this can be done ex parte without notice. Now, they're contending that email isn't service, but we are not required to show service for today because this is in essence an ex parte proceeding. The court was very clear in setting this down for a hearing with what you, Your Honor, would be expecting of me at the outset of this hearing to show that I tried to serve Ms. Richardson in the formal sense, and I'm prepared to address that this morning. There's an affidavit that my process server has filed. There's an affidavit that I have filed. Both are on record with the court, both sent to Mr. Freehoff yesterday morning. And I've got them here pulled up as exhibits to enter into this morning's hearing. But essentially, we tried to serve her at last known address, and I even addressed with counsel yesterday when he called me if he would acknowledge service or cooperate with acknowledging service when you raised that as an issue, and he declined. And obviously, Ms. Richardson's here this morning, so she's confirming actual notice and failure to cooperate with being formally served. I don't think that's grounds to have this morning's hearing continued because it is by its nature an ex parte request for an emergency restraining order, which we have presented evidence on with the verified complaint and the affidavit of David Wolf that we filed yesterday and also sent to Mr. Freehoff and to Ms. Richardson. Now her counsel would have access to it through her. And all of those things will point to the evidentiary basis for us to be able to get our ex parte relief that we seek today. So for all of those reasons, Your Honor, we are objecting to the request for continuance.
Okay, thank you. Yes, Ms. Richardson?
If I may, Your Honor, I'm so sorry. I've never been in this situation. So
You're doing fine so far.
So the request is, I just don't feel comfortable moving forward without proper service or legal representation. The case in point, I've never been in a courtroom, and I don't believe the court can hear my case until service is done correctly. I also just have to say the pressure to be here today was because of the lack of time I had. I did not know about this until Friday evening. I'm not in the state, and the attorney that I have representing me, I barely know. And he is in the state of California because that's where I do a lot of business as a professional filmmaker. But I just would really respectfully request a continuance just because I feel very out of my depth here.
Thank you, Ms. Richardson, and Ms. Brown. Excuse me. So, Ms. Richardson, I understand your trepidation, your hesitation. I understand your concerns and the objection that you've stated here. But Ms. Brown is correct, right? So the way this works is this is an ex parte, essentially, which is a fancy legal term for your benefit since you're not a lawyer. That means I could have this hearing with only Ms. Brown. With no presence here of the other party. And it is her obligation to either satisfy or not satisfy the standard that would satisfy me that she's entitled to some immediate temporary relief. Now, that is different and separate from your right to be sued or to be properly served with the lawsuit that has been filed against you. And that is a different matter that I'm sure that Ms. Brown is undertaking to effectuate proper service on you in whatever manner is appropriate. And the reason that we're doing it this way, the reason that you receive notice at all is that it is the policy and procedure of Fulton County that when someone requests ex parte relief, we often, if we give ex parte relief where no one is here and no one is on the other side, we will just have to do it all over again in about a week and a half or 2 weeks. And so instead of doing that, we have a procedure like this where the party who's seeking the interlocutory relief will either get notice to the other party so that the other party can be here, or will satisfy this court that they've undertaken every reasonable effort to ensure that person's presence or to make sure that they were known, that the person knew that the hearing was going to take place. Your presence here indicates that Ms. Brown satisfied that obligation, which was to make sure that you were aware. That is very different than proper legal service, and that's a different matter for us to talk about on a different day. For today, however, notwithstanding your objection, the hearing can go forward. Ms. Brown, I have read the submission that you previously made, and so it would be very helpful to me if you could be as efficient as you can in terms of the nature of the relief that is sought, and because I am aware of the basis for the relief in terms of what the dispute is generally, and that the nature of I think I understand the relief to be to limit Ms. Richardson's ability to sell, market, or, I can't think of the right legal word, this product that is this potential film to which Throttlebox argues it may have ownership rights. And so if you could focus on the nature of the relief that's requested, and of course the elements for why such relief is acceptable and not any greater than necessary to accomplish or protect the interests that are at issue here.
Understood. And first, thank you, Your Honor, for reading the things that I submitted, because that certainly helps both of us. I do want to confirm, because there were multiple submissions. Are you referring to the verified complaint that we submitted? I think it was May 22nd, but we also submitted an affidavit of L. David Wolf that was Dropbox to Mr. The size was, kept me from just emailing, but it was sent to Mr. Freehoff. Have you had an opportunity to read the verified complaint as well as Mr. Wolf's affidavit?
I have not read the affidavit in detail. I have read the complaint, so I'm familiar with the nature of the relief that you are seeking and the nature, at least of what I think is at the crux of what is at issue. The reason I keyed in, and so feel free to educate me about what you've represented for in Mr. Wolf's affidavit, what he has testified to. The reason I mention that though is because if we are focused on a particular type of relief, which is the extent to which Ms. Richardson can alienate in any way the ownership rights that she has to the film product, at least I think that's what I understand, then let's focus on that, because the larger issues to me of the alleged wrongful conduct, et cetera, those are things that we're all going to hash out at a later time.
Understood, and I'll do that, Your Honor. And I guess first, in terms of, you've already established that we can go forward today. To the extent that you'd asked me about my efforts, and I think we're past that, but I had prepared P1 affidavit of my process server and P2 affidavit of Christine Brown that I'd like to just tender into the record, if I may. I don't think I need to go over them because I think you've indicated we're past that, but if I could tender those for admission, please, at this time.
Yes, you may. Go ahead.
And then I will also go ahead and tender P7, which is the complaint, which you've indicated that you went through, asked that those 3 be admitted. And now I'm going to summarize and sort of proffer what's in the affidavit of Mr. Wolf, just to sort of keep things moving along. And if you want me to put him up beyond that, I can certainly do that. The affidavit essentially highlights.
Forgive me. Sorry, Ms. Brown. Just
Sure.
so the record is a little cleaner, you'd offered P3, which you've represented as the complaint. I'll just let you know that P3, assuming that it is unchanged from the one that was filed with the court, is docket number 1 on my docket. I'm looking at it right now. Mr. Wolf's affidavit is docket number 9 on my docket. And so as far as I'm concerned, those are both matters that are properly before the court with or without your admission of those documents.
Okay, great. And it was P7 for me.
I'm sorry.
So that's okay. So you're admitting docket number 1 and docket number 9 as my P7 and P3.
Yes.
And P1 and P2 were the 2 affidavits with regard to service. So can all 4 of those be admitted at this time?
Yes.
Okay. Then with regard to the affidavit, essentially, and to speak to your concern and the reason why I asked us to gather here today, the complaint sets out that the parties somewhere in about February of 2023 were introduced to one another. Throttlebox and Ms. Richardson started having conversations. Ms. Richardson was represented to be somebody who was experienced in the industry, who could connect Throttlebox with location, cast members, props, all of the vendors necessary to shoot a film known as Selena, which is my client's film. In consideration of the conversations that ensued from February until the actual shoot was to begin in October, the parties reached an agreement. That agreement is memorialized in emails between Throttlebox and Ms. Richardson, and between Ms. Richardson and third parties. In other words, it's confirmed that there was an agreement with her emails to third parties, and a budget that is 2 budgets actually, one that was sent to Throttlebox from Ms. Richardson in August of 2023, and then a follow-up budget in September of 2023. All of these things are attached to Mr. Wolf's affidavit, so they're already in evidence, but I'd ask you to sort of refer to those. I can put it up on the screen if you want me to screen share, but essentially—
I actually have it open on my screen and I'm able to look at it while you're referencing it. Yes, Ms. Richardson?
Your Honor, I just have to ask once again, I understand that we have 2 separate issues here. Forgive me, the name of what the injunction and then the actual lawsuit. Everything Ms. Brown is saying, I cannot contest today because I don't have any paperwork. I don't have anything I wasn't given enough time. That's why I'm asking for a continuance. And the injunction, this is something, as she said, is from 2023. There's never been anything filed until a week ago. So I'm just really not understanding what the emergency is and where the irreparable harm or damage is coming from.
Ms. Richardson, those are all fair issues for you to raise. It's just that the first objection you made was to the hearing taking place at all, and I've overruled that objection. So the hearing is going to take place. And so what that means now is that it's Ms. Brown's client's opportunity to present, and then you would be given an opportunity to respond. And the things that you're saying about whether or not Ms. Brown's client has satisfied the factors that you're outlining about irreparable harm and other things like that, you would have an opportunity to represent, make those arguments to me at that time. For now,
Understood.
my understanding, Ms. Brown had represented that she had provided by email a copy of at least the petition, and possibly, I thought I understood the affidavit as well.
Your Honor, yes, last Friday, the date that Ms. Richardson acknowledges through testimony today and through her counsel to me yesterday, and again by letter last evening from her lawyer, as of May 30th, she received the email that I sent to her, which included all the filed pleadings as of that time. It was the verified complaint. It was my certification of counsel as originally written for the injunctive relief. It was the request for the ex parte hearing. It was your notice of hearing. For today, it was, I actually downloaded the court standing order and sent that to her so she would be fully apprised of the obligations of the parties to prepare for the hearing. I think there were 7 things. Oh, I included as well an acknowledgement of service and asked her to acknowledge service at that time. And again, I revisited that with her counsel yesterday.
Thank you, Ms. Brown. I'm actually most interested in whether or not you've provided her with a copy of Mr. Wolf's affidavit and the exhibits.
Yeah, yes,
Okay.
I'm getting to that. So to yesterday, when I Dropboxed things to Mr. Freehoff, I included Ms. Richardson on the Dropbox share. And the court, if you wanted to verify what I'm saying, Mr. Freehoff can go in and see that she is included as one of the members of that shared folder with the court. And that includes.
I'm certain that's the case, because if Mr. Freehoff had received it in any other form, he would have advised you that we couldn't receive it because it wasn't included, that the other side was not included. So I'm not concerned about that. It was mostly just, Ms. Richardson, I do not mean to discount in any way the overwhelming nature of what's happening when a bunch of people, myself and Ms. Brown, who went to law school, start talking about what we're talking about, and they can be overwhelming. But it is legally proper, at least based on the ruling that I've made so far. And Ms. Brown did, in terms of due diligence, provide you with the documents that we are discussing. Now, you may not have had a chance to review them in the detail that you would like to review them, or to understand them and discuss them with an attorney, but I am aware of those as shortcomings of this hearing, and the hearing is still going to proceed because it's my understanding that you do have the documents. You maybe just haven't had an opportunity to review or understand them or discuss them with an attorney. So with that explanation, Ms. Richardson, I am going to ask Ms. Brown to continue with her presentation, and I can assure you that I will call on you and give you an opportunity to respond when she is done with her presentation, okay?
Thank you so much, Your Honor.
Thank you. Ms. Brown, please go ahead.
Yes, ma'am. So with regard to your question, the affidavit of David Wolf is included in that Dropbox, as well as mine and the one from my process server. I also, those have been, already put into evidence. The affidavit of David Wolf has all of the exhibits that we're relying on attached to it. So she got that in the Dropbox. And then, out of an abundance of caution, when I received a call from her California counsel yesterday, I let him know that everything that I'd submitted was either emailed to her that Friday, which he'd acknowledged, or was in a Dropbox yesterday that she could download and present to him and go over with him last evening if she chose to do that. Substantively, getting back to our request, there was an agreement between the parties, Throttlebox and Ms. Richardson, that Selena would require 3 days of filming, and REM, a film that Ms. Richardson was proposing to be joined with the Selena production, over a course of 4 days, with 3 days allocated to Selena and the 4th day allocated to REM. And then the parties would share budgeted expenses. Ms. Richardson would be the producer. In other words, she would tee up getting the location, getting the cast members, getting the vendors lined up, getting the props, all because she had these connections in the industry over, I think, 15 years of experience, which was specifically why Throttlebox was referred to her for collaboration on this effort. In exchange, Throttlebox was to fund the production of both films. They were to share these expenses, and the budget that I mentioned previously, one in August and an amended one in September, was a joint budget for both of the ventures that were to be done together. Included within that budget, critically, and again, both of these budgets are attached to the affidavit of David Wolf as exhibits. Let me get to that so I can draw your attention to it since you had it up on your screen. It's 6 and 7 attached to Mr. Wolf's affidavit. Critically, in line 1000, I believe it is, there's a line item for story and rights to the productions, and that includes REM. And there was payment for it. Throttlebox paid. These movies proceeded to production. The parties, things didn't happen the way they were supposed to. All of this is particularized in the complaint, so I won't go into it more now. They didn't happen the way they should. Miss Richardson completed REM. Selena remained incomplete, had to be reshot, and couldn't proceed with post-production efforts. And to this day, efforts that Miss Richardson was supposed to see through are still incomplete with Throttlebox. Meanwhile, Miss Richardson has taken REM, done the post-production edits to it, and pertinent to today is publicizing it. And this is in the affidavit of David Wolf. And at the very end, we put up examples of what she's publishing. And to the world, she is saying that, number one, that REM is hers. Number two, that it's going to come out and it's coming out big, that it's been in the works for well over a year, that she's excited about it. There is no mention of Throttlebox having any participation in it. And she's holding it out as her own exclusively. These things, and I'll ask you at this time to go to Exhibit 12 of Mr. Wolf's affidavit, where you can see the examples that I'm speaking of. Most recently, and this was even after the filing of the plaintiff's complaint on May 22nd, there is a globally recognized film festival, which I'm learning about some of these things as I'm getting more involved with the case, but it's the Cannes Film Festival that is for the world to see. And Miss Richardson is posting within that festival to prospective filmmakers, to prospective participants, to collaborative efforts, and to prospective viewers all over the world, that this is hers, and that Throttlebox has no, it is not even mentioned within it. And you can see from the exhibits attached to number 12, REM, a short film inspired by my work, is coming out this year. It's finished, and I can't wait to share more with you. And then you go on to see other things. Extremely proud of the Hainted Homie at Blair Bathory. Extremely proud of everyone that worked on the film. Far too many to tag. Here's a picture from Cannes, announcing my new film at the Cannes Film Festival. I mean, all of these things are reaching the masses, and she's taking over the ownership, which rightfully belongs to Throttlebox. I do want to bring up at this time, there's a transcript that I didn't get until this morning because we had to have it transcribed, but I'll go ahead. It's short, and I want to go ahead and just kind of read it into the record. But this is a video that Miss Bathory posted, or Miss Richardson posted, who, by the way, I think we've established in the complaint, Miss Richardson goes by Blair Bathory in her screen name, if you will. In May of 2025, by Miss Richardson, y'all, I can finally announce my new project, and I get to do it at the Cannes Film Festival. Oh my God. This is my new short film I've been working on for a very long time, and it's starring Emmy Ramey, Kelsey Davies, Tyla Harris, and Lizzie Yu, also featuring the great Bonnie Aarons. I worked with so many incredible people on this, and we're just waiting to hear about the film festival submissions that we have sent this film to. So please stay tuned for its world premiere announcement, but this is it, REM. This is what brings us here today, Your Honor, is Throttlebox owns this film, and Miss Richardson is taking it as her own and publicizing it. That is the activity that we seek to stop. Critically, Miss Richardson signed a non-disclosure agreement with Throttlebox before they ever began. This was back in April of 2023, early in their discussions, that she would not be taking ideas that my client presented to her for the production of Selena, which included, and this is attached to Mr. Wolf's affidavit as well, the entire script for Selena that was shared with Ms. Richardson so that she could be certain to make the selections as producer of the film that were fitting for Selena. With regard to the four prongs, and I'm kind of working my way through them, although in not any particular order, but the four prongs that the court I know is going to consider with regard to injunctive relief that are set out in the case law. With regard to the substantial likelihood that we will prevail on the merits of the claims at trial of the plaintiff, the contract is set out in the affidavit of Mr. Wolf. The script is referenced in the affidavit there. And Ms. Richardson was specifically, and this goes to our complaint and the damages referenced therein, she was specifically supposed to secure a location that fit with an interactive, but it was to be a video game. It was an interactive film, and it required intricacies that somebody who was experienced in the industry, such as Ms. Richardson, was supposed to provide. It was a live action interactive video game built for streaming platforms.
Your Honor, may I object?
To be.
May I object?
Yes, on what basis?
Is that allowed?
Mhm.
I don't know what the word is, but I thought we were here for the injunction, which is to prove some level of harm that I'm doing. Everything that Ms. Brown is saying, I would really like to defend because it is not fact, it is not true. Throttlebox does not own this film. I have not been given time to get representation. I understand we're here for a matter of the injunction, but
Okay, fair enough.
She's going through the whole case.
I understand. So the reason that Ms. Brown is doing that is because there are four factors that the court is to consider when deciding whether or not to grant the relief that is being sought here, right? Which the purpose of which, it's always a good reminder, is to maintain the status quo, which I understand their general request is to limit what actions you might take with this film. I think that's the general tenor of the relief they're requesting. But basically what they have to demonstrate is that there is a threat of irreparable injury to them, that the threat of that injury outweighs the injury that might accrue to you if I were to grant them the relief that they request. The third factor the court is to consider is what Ms. Brown was talking about, which is the likelihood that she will succeed, that her client will succeed on the merits of the case long term. And then the fourth factor is whether or not, an injunction serves or disserves the public interest. So that third element is what she was talking about. And Ms. Brown, I'm going to overrule Ms. Richardson's objection in the sense that obviously you're entitled to go into some of the merits of the case if you're going to talk about the likelihood of you succeeding on the merits. I will tell you, though, that I find that if the purpose of a true interlocutory injunction is to maintain the status quo, then really what we're talking about is, let's assume for a moment that there is a likelihood that you might succeed on the merits. The nature of the relief is intended to only maintain the status quo, and it's supposed to be relief that is as narrow as possible so as not to unduly harm any party involved and or the public interest. And so that's why I sort of started with, let's set that aside for a moment and focus on what is exactly the nature of the relief that Throttlebox is requesting, and how does it serve to protect the status quo as it currently exists?
Sure. So this can best be described. I filed an amended certification this morning and sent it to Mr. Freehoff, and poor Mr. Freehoff was getting busy with our stuff this morning from both sides. But in there, and I'll just go ahead and sort of read from it with your question, we are asking that the court enjoin her from any further publication of any sort. Things have been shared, posted, reposted, distributed throughout the filmmaking community, participants therein, and prospective viewers under her identity, meaning Ms. Richardson's, to the exclusion of Throttlebox. Notwithstanding the parties' agreement, what we're asking for is that she be enjoined and restrained from actively advertising, marketing, posting, distributing, selling, and or attempting to do any of the foregoing acts, and or otherwise using the story and or rights to the film rem for her own pecuniary gain or other benefit. Okay. That is irreparable harm, and specifically what we are contending will be the harm, and this goes to those four factors again, is my client will sustain loss of film and other credits, loss of relationships with filmmakers and other participants in the film industry, loss of opportunity, damage to his reputation, defamation, loss of revenue, the extent of which we can't currently quantify. And I think this goes to the fact that we have no adequate remedy at law when we're making this request. I think the spirit of 9/11/65 asked counsel for the moving party to put that in writing before the court. And I have done that this morning in my amended certificate, but also in the record. With
Ms.
regard
Brown, sorry to
Yes.
interrupt. I have two
Sure.
questions.
Yes.
Number one, and it goes directly to your point about whether or not you have an adequate remedy at law, right? So I understand that your client's position is that your client owns the REM film. And so one question I have is, what about why is a suit for damages, for monetary damages associated with the deprivation of the value of this movie or film or whatever it is? Why is that not an adequate remedy at law, number one? And number two, from a injunctive perspective, in terms of irreparable harm, if your client claims an ownership interest in that film that it might later vindicate in this lawsuit, then isn't it to your client's benefit for that film to be worth as much as possible? And so why would we want to enjoin the film from being marketed and made more valuable if the long game is it belongs to Throttlebox, and now, Ms. Richardson, whatever the value of that movie is, you now owe us? And I may be overthinking this, but I'm trying to play out, why is that not, one, a lawsuit for damages for her wrongly taking an asset that your client alleges belongs to them? And two, in terms of mitigation of damages, right? Like, why wouldn't we want that film to be able to be advertised and marketed for your client's later benefit if you demonstrate that your client owns it?
Well, a couple of things. So you asked me two questions, so I'll attack the first one first, and that is how does the ownership rights not translate to a money damages thing? And our complaint for damages that was filed has two aspects to it, several counts to it, but essentially we have a budget that was sent for about $42,000 before the filming began. And one of the claims set out in the complaint is that the actual budget was like $70,000, or the actual receipts was over $70,000 spent on the two films, the majority of which went to REM. So we have a money damages claim for the fact that over $30,000 is essentially unaccounted for and didn't go to the production of Selena that went to REM. That's a separate issue from the second question that you asked me to address, which is, why don't we have an adequate remedy at law? It's because now what she's doing is taking REM, publicizing it as her own, and not acknowledging Throttlebox at all. We don't have a way to quantify that. What we need her to do is to stand down on that and let us get together with her lawyers and figure out a proper procedure going forward. And that is the essence of the injunctive relief and the status quo. But we are asking the court to take things one step further, because not only do we need her to be enjoined from further posting because she is not posting, recognizing that Throttlebox was involved in this production, but there are things that have been put up that are already and have already caused Throttlebox irreparable harm. And this goes to those four factors as well, because she's getting all of the credit. And the longer they stay out into the public eye and aren't pulled, then she's getting all of the credit for this, and Throttlebox is getting nothing. Meanwhile, he's losing contacts, he's losing professional liaisons, he's losing people who might be interested in acquiring the film for money. These are opportunities that are seized early on in this process that he is being excluded from because she's doing the posting and the claiming. So we just need an opportunity, and hopefully Ms. Richardson will hire counsel and we can get this under control and we can get with them and start sorting all of these claims out. Regardless of who gets the story and rights to REM at the end of this litigation, and we believe our case is strong for that, establishing early on that it doesn't go to Ms. Richardson is critical, because she's misusing the story and rights to that film that belongs to Throttlebox. And so if the court does not think about an injunction at this point, there is no adequate remedy at law. We've been asking Ms. Richardson since as early as December 22nd of 2023 in multiple emails, and these are all attached to Mr. Wolf's as Exhibit 10 in his affidavit, Exhibit 10, sub exhibit, if you will, 1, 2, and 3. These are emails we sent to Ms. Richardson well before this litigation saying, stop, you're publicizing, you don't have permission, we own the story and rights. And because she has ignored all of those attempts over 18 months of time and continues to proceed, that is where we don't have an adequate remedy at law. We are asking for the court to intervene to get her to stop. These things are being published and then they're being spread to people who are tagged and reposting, and it's becoming this mass distribution to the exclusion of Throttlebox, and we have no legal recourse for that. The only remedy is to get her to stop while we litigate the case. Moreover, as I said, we're asking the court to ask her or direct her to pull them down. They can't be discarded or deleted because they're evidence. They're evidence of our damages at some point. But we're asking that those be downloaded, turned over to counsel, and that we just have an opportunity to litigate the case, all of the claims referenced in the complaint. Ms. Richardson has indicated her concurrence that she needs an opportunity to come in and defend. We're asking for that status quo while we do that. But to your point, there is no adequate remedy of law to cure these things that have been happening for 18 months, but in an obvious escalated fashion. In other words, the distribution is compounding and getting more critical. Most recently, as I mentioned, in this globally recognized Cannes Film Festival, it's getting worse. And she's being allowed to capitalize on that to the detriment of Throttlebox. That is irreversible damage, Your Honor, which is why we're asking you to limit that. I think I've addressed with regard to those 4 prongs. I think in number 1, that's established in my certificate that I've laid out about the irreparable injury to my client. I think I've just spoken to that as well. The injury to the threatened injury to the plaintiff outweighs the threatened harm that Ms. Richardson may suffer from being enjoined. Well, that's established in my certificate, the verified complaint, the affidavit of Attorney David Wolf, showing the mutual assent to all the material terms of the contract. So for her to just be simply ordered to stand down while we argue about the terms of that contract and who has the rights to that film, that's not going to cause her any harm that would outweigh the potential harm that it would cause to the plaintiff. I started to speak to the fact that there's substantial likelihood that we would prevail on the merits of the claims at trial, and that's when Ms. Richardson imposed her objection. I think the court has noted the complaint and the affidavit, they're already of record. So I don't know that I need to go further into that, but the contract is established, as I said, particularly in the evidence submitted at the back of Mr. Wolf's affidavit, as is the posting. So those examples are there, and that's just a few select portions. That's not all she has done. We just wanted to give you some choice selections. With regard to the 4th prong, whether granting the interlocutory injunction will disserve the public interest, Your Honor, there is an interest in affording parties who contract privately to the rights to a story and upholding those private agreements. Moreover, I think there's a big interest that is served by making certain that somebody is claiming and publicizing rights to a film that one does not own. So I think the public interest would be served by upholding the private contract of the parties, number 1, the specifics of which would be dealt with in the merits of the case. And secondly, make certain that somebody is not allowed to benefit and capitalize on something that belongs to someone else. And that is how I think the public interest would be served, specifically in the movie making industry, because she is in essence taken something that's belonging to Throttlebox. She has also, you will find this in the affidavit of Mr. Wolf. He has on at least 3 different occasions in these emails that I mentioned previously on Exhibit 10 to his affidavit, he's written to her, number 1, and he said, stop publicizing. But number 2, he has said, we own the story and rights to REM. She has acknowledged by writing back, but she's never come forward with any denial that the story and rights belong to REM. Don't know what she's going to tell you today about that, because it would be somewhat self-serving for her to say that it's hers, but there's nothing that I think she'll be able to produce today written or otherwise, that will show that she is actually the owner of REM. I think contrary to that, we have put in evidence and will put in evidence during the trial of the case that movie, that REM belongs to Throttlebox. And I do have a case on that. I know you've not really asked me to argue at this point. I don't know if you're going to hear from Ms. Richardson before we hear remarks, but I do have a case that shows that, certainly emails and correspondence between the parties can establish a contract. I've got cases that show that oral agreements can establish a contract. And I've got a case that shows that where one party has a varying interpretation of a contract and sends something over, such as an email to someone else, and they don't respond back with an objection or a different interpretation, then the person who sent the original email's interpretation is permitted to stand. So in Exhibit 11 of Mr. Wolf's affidavit, Ms. Richardson acknowledges the contract between the parties. There are also, as I mentioned at the beginning,
I object to that,
Yes,
Ms.
ma'am.
Brown. I'm sorry. I
What
object
is the
to,
nature of your objection, Ms. Richardson?
I don't, everything that's been said just now is not true. And I would really like the opportunity to defend myself.
So,
I have
Ms.
all the
Richardson,
proper paperwork.
Forgive me for interrupting you. I understand your objection, but I disagree, or it's not true, is not a legal objection to prevent her from making the presentation. She's making an argument on behalf of her client of the fact she believes she can demonstrate. You
Yes,
will
ma'am.
have an opportunity to respond in a moment. If you have a different type of objection that you want to raise, you're welcome to raise that. But I disagree, or what she's saying is not true, is not a legal objection. It is merely that you disagree with what she's presenting. And when Ms. Brown is done presenting, I will allow you to speak and you can tell me what you believe to be the correct facts. Do you understand that, Ms. Richardson?
Yes, Your Honor, it won't happen again.
Thank you. Ms. Brown.
Yes, ma'am. So just a couple more points with regard to that, and I know she'll have her time to speak, but in Mr. Wolf's affidavit on specifically Exhibit 11, one of the emails that we've provided to you, and it's the one that's her responsive email on June 24th of 2024 at 7:53 p.m. Specifically says, in my role as producer, and then she goes on to talk about things that she, quote unquote, did her best to do. So she does acknowledge that role there as well as other places. There are a couple other things that I wanted to just go ahead and put into evidence. The transcript I've marked as P6, which is what I read from. That's from the film. And I did send those over to Mr. Freehoff, although this morning, because I didn't get the transcript, or P4, the non-disclosure agreement that Ms. Richardson signed for Throttlebox, which is at least extrinsic evidence of the parties' agreement. So I wanted to put that in as additional evidence. So I would like to tender P6 and P4 at this time.
Okay. Two things. One, the transcript that you're referring to, refresh my memory, it's transcript of statements made by Ms. Richardson.
It is, and that's
Okay.
what I read into the record about her promoting her new project.
Just for purposes of admission, I wanted to make sure I understood that.
Yes, it's
Secondly, Ms. Richardson, I'm not asking you to agree that there is a binding non-disclosure agreement or that you agree that it's binding on you in any way. But the document that Ms. Brown is indicating there is a non-disclosure agreement between you and Throttlebox. Is that roughly accurate? Do you dispute that there was a non-disclosure agreement?
I dispute that it has anything to do with REM.
Understood. Right. But the only reason I'm asking is that for purposes of admission, right?
Yes, ma'am.
She's representing that there is a signed non-disclosure agreement between the two of you. And when she's doing that, all she's doing is saying, this is a non-disclosure agreement between the parties, not what it says or what it means to the case.
Yes, Your Honor.
Okay.
I believe so.
Okay. Thank you, Ms. Richardson. Ms. Brown, go ahead.
So I'd like to tender P4, the non-disclosure agreement, and P6, which is the transcript of the statements made by Ms. Richardson.
Okay. Thank you, Ms. Brown. They're both tendered and admitted.
All right. And then lastly, I have P5, which is my amended certification of counsel that sets out the 4 prongs and sets out the damages that my client would sustain if the injunction was not granted, and the manner of the relief sought, which I'd read into the record a bit ago, but I'd ask that you tender or admit P5 as well.
Okay, so just again, that document is in my record. It is filed as a docket number 12 in the court's docket. And so, I mean, I'll admit it if you want me to. There's no reason for me to exclude it. It just doesn't need to be here because it's docket number 12 and I already have it. I can see it and I've read it and you've read it to me. And so if you want to tender it, it's tendered and admitted, but it is reflected as docket number 12.
Okay, and I hate to be difficult, but I would like to tender it because I think it's required to be in writing for me. So if you wouldn't mind indulging me, I'd appreciate that.
Yeah, that's fine. I mean, like I said, you've tendered it and I don't have a problem admitting it. It's a part of my docket. So go ahead. It is admitted.
So that should be, I should have P1 through 7 in the record at this time, in the docket and in this proceeding. I understand they're kind of one and the same, but.
Yeah, that's what my notice, that's what my
Sure.
notes indicate based on what you've requested so far.
All right, thank you. And excuse me. P6 is in. Yeah.
Tell you something.
Oh, excuse me one moment, Your Honor.
Yes, ma'am. Feel free to mute.
Specifically, Your Honor, with regard to P6, which is the statement from Ms. Richardson in a video that she put on social media, that she specifically says she's submitting that to other films, and we're seeking to enjoin that, submitting REM to other film festivals. So as I mentioned before, the problem is getting worse, and it's going to continue to get worse if the injunctive relief that we seek is not there. I do want to mention another thing, though, with regard to, we talked about the injunction and the status quo. We're asking for a bit more than status quo today because of these things that have already been put up that we're asking to be taken down. And I mentioned before, you know, it won't just cure the defect if she stops. It will help, but there's been a lot of damage that's already been done. So we're asking the court to restore the parties to a point of neither party is posting the videos. I understand that's asking a lot of the court with regard to these 4 prongs, but you know, in terms of our ability to litigate the case before either party continues posting, we think that the ones that have already been done ought to come down for all of the reasons that I stated. And again, I mentioned they've got to come down in a way that they're preserved by counsel so that they're not destroyed. So in my certificate of that I filed earlier this morning, that is in the record, describes that I think it should be done in such a manner. That's everything that I wanted to present to the court about the 4 prongs. I would ask for an opportunity to argue some case law about the merits, only as it relates to a contract. I understand we're not here about the merits of the case today, but to the extent you want to hear from me more about my likelihood to succeed on the merits, I think I can offer some cases relative to oral contracts, course of dealings between the parties, and so forth. But I think the most critical thing that I needed to present to you today were those 4 prongs. And I think, let me, just so that the case is in the record, I keep referring to the prongs. I know the court's aware of the prongs, but Federal Defender Program versus Carr is one of the cases I found. There are many, many cases that cite them because they're sort of foundational prongs for the injunctive relief. But that is at, well, I don't have a Court of Appeals site on this one somehow, but it's decided May 17 of 2022 in the Superior Court of Fulton County, actually. And it's relying on as well Wood versus Wade. I do have a site for that, 363 Georgia Appeals 139. That's also a 2022 case. So those are 2 recent cases that deal with those 4 prongs for the injunctive relief. And Mr. Wolf is available to answer more questions. I tried to succinctly state, you know, what was in his affidavit and how it correlated with the complaint and our likelihood to succeed on the merits with regard to that prong. If you have any questions about the affidavit or any of the exhibits, he's available and I can put him up, swear him in, and have him testify, or he can simply proffer. He's an officer of the court. Thank you.
Thank you, Ms. Brown. Ms. Richardson,
Yes, ma'am.
now is your opportunity to tell me what you disagree with or what you think I need to know. I would like to give you, I can't give you legal advice. I'm not your lawyer, but I do, just to help you frame what we're discussing. As I said, the concern that the court has currently, and you've heard us have this conversation, But
Yes,
there are
ma'am.
4 factors the court is supposed to consider. That is the threat of irreparable injury that might occur to Throttlebox if I don't give them the relief that they're requesting. The fact that they have to demonstrate, and these are factors, if anyone isn't there, it doesn't mean it doesn't count. It's just these are things that the court should consider. The second one is the extent to which any relief they've requested, that the injury that would inure to them is balanced against the injury or limitation that might accrue if I grant the relief that they request. The third one is the extent to which they can demonstrate that they would be likely to win on the underlying merits of their case. And then the fourth one is whether or not it, serves the public interest or disserves the public interest. I will also add, you've probably heard me ask Ms. Brown some questions regarding the extent to which there is an adequate remedy at law. And the reason I asked that question of Ms. Brown is the relief that is sought here is extraordinary relief that is only supposed to be granted when there is no other relief that might be able to address the issue. And so those are the factors that the court is concerned with. And if you could sort of direct your comments on those issues, that would be helpful to me.
Thank you, Your Honor. Just to begin, I'm saying this without waiving any rights or the special appearance, and I deny all the plaintiff's contentions. I can very easily prove that I own the film. There is no proof of disposition of the film, and copyright requires a piece of paper from me to them, giving them ownership that does not exist. And that does not exist in emails. There aren't any emails with transfer of ownership. I do have to just say once again, the plaintiff has always had the ability to contact me directly. He has not spoken to me since November 2023. I believe there's an email. Again, unfortunately, I don't have any paperwork or evidence to submit, but currently, but I would love the opportunity to do that. There is an email from me saying I am here until the project's done. I am not walking off this project, and I am available until it is finished. And I still maintain that to this day for his project. I think under the circumstances, this very severe injunction that is trying to be placed on me with such little notice, it feels like a pressure move, not an emergency. And, it's 2 very powerful men going after a woman with limited resources, and the statute is not intended to cover this. And Throttlebox just cannot prove that they own this movie. And also, everything that they've mentioned is from social media, my personal social media, me presenting as myself as a writer and director. I've been posting about RIM since the day we shot it, which was October 2023. And that is when these projects started, and we've been both working on our projects this entire time. There's nowhere that says RIM is completed, and RIM has never screened anywhere. The things that they've mentioned is a poster. I shared a poster because I was working at the Cannes Film Festival for a different company, and it was just excitement. I just wanted to share something on my own social media. If the issue was that Throttlebox wanted to be named on any of my social media posts, they just needed to ask. They've never asked that. So I just, once again, I don't understand what the emergency is or the harm. I have never prevented the plaintiff from doing his own project. In fact, the crew that was used the first time has been used over and over and over again. I've never stepped in to prevent that. And once again, I'm still here to help him finish his project.
Thank you, Ms. Richardson. Ms. Brown, you had asked, I mean, it's technically your motion, so I was going to let you have the last word anyway. I will say that one point Ms. Richardson made, it was a question that I was going to follow up with you and ask, and that is, in terms of crafting something like the relief that you're requesting, I definitely do not understand, how this works from a financial perspective and who, how people are marketing things using social media and other traditional media, how people are trying to get in front of Cannes. I guess part of what I'm not understanding, particularly one thought that had floated through my mind is if Ms. Richardson were to continue her social media marketing activities or advertising activities, but include Throttlebox, why would that not satisfy the concern? And I think that's part because I don't understand what your client is asserting about the harm that is inuring to him. I mean, clearly, if the film belongs to him, I understand that harm. That's clear. I can understand that. But you are right that the relief that you're requesting is more than the status quo, because you're actually requesting that the court prohibit the parties from doing something they're already doing, right? Which is, or at least that Ms. Richardson is trying to do. And it sounds as if Ms. Richardson has indicated she would be open to the idea of jointly marketing the project while the parties sort out who owns what and who owns the project, what financial interests the parties respectively have in it.
Okay, so I'll break that down a little bit. The ownership, there's no evidence presented by Ms. Richardson that she owns REM. There's no registration or copyright or any of the intangible things you might expect to see if she were to show up for a hearing today and she knew that the ownership interest of REM was going to be discussed. So she's presented no evidence. Conversely, the plaintiff has presented through the affidavit of David Wolf in two different places, two different budgets that by agreement now were a collaboration of two films where the story and rights is a line item there. I think I mentioned before it was 1,000, and it is for both the films, and there's a payment therefore, and Throttlebox had issued the payment. So
right, but Ms. Brown, doesn't that payment, right, assuming I accept it for what it is, doesn't that imply that it's Ms. Richardson's and that it was, depending on the facts as they are borne out, purchased by Throttlebox, whether it was or was not, right? Because that's, as I understand it, the basic issue is Throttlebox believes it has some ownership interest in this project because of funds they expended for the development of the Selena project. That's a very basic understanding. And I guess my point is, doesn't that representation of how Throttlebox came to have an ownership interest in the REM film, doesn't it underscore the fact that Ms. Richardson clearly had, even if it is no longer, an interest in that project?
So we are unaware of where REM originated. I will appreciate that Ms. Richardson brought the concept of REM to the table, but we absolutely purchased those rights in what we paid to do the production, the story and the rights to REM. So regardless,
I'm not disputing that. All I'm saying is that if your client paid a substantial amount of money to Ms. Richardson, then your client, at least at some point, believed that Ms. Richardson owned the rights. And so I'm just saying, I don't think you're getting anywhere by saying she can't prove she owned it, right? Because it seems like everybody thought she did. And that's why there was effort through contract, through course of dealing, through these budget line items, through this joint venture, whatever we're going to call it going forward, to purchase the rights and interests to the film. So that's all I'm saying. Is not a foregone conclusion or a predetermination of the facts you're arguing. Just, I don't think we get anywhere by arguing that Ms. Richardson has no interest other than an interest she previously had that was obtained by Throttlebox.
Understood. So I think the essence of what we're asking for, though, is that the injunction would serve so that neither party can do the posting because the ownership rights, the story and rights are in fact in dispute in the merits of the case.
Right. But again, Ms. Brown, forgive me for interrupting, but to Ms. Richardson's point, and I had asked you the same question during your original presentation, to some extent, you're asking to devalue this asset that the parties are arguing over. And if part of what Ms. Richardson is willing to do is allow you to jointly market it so as not to lose the potential value of a film being acknowledged at an international film festival, why wouldn't that be the appropriate status quo so that there's a value to this asset that we're continuing to fight over long-term in the lawsuit?
Understood. And this is the first time that Ms. Richardson has even discussed that might be an option. And all of the emails that we've sent objecting to her publishing it, she's never said hey, come on, be a party to this. I'll recognize you too. Let's both be on there. It was a collaborative effort. Had she done that, we might not be here. I don't know, but I would ask for an opportunity to go over that with my client. I mean, certainly if I don't know if the court's inclined to make a ruling from the bench or not, but excuse me.
I could respond.
Okay, actually, Mr. Wolf is asking to respond in that regard. So
Should I
Okay.
be speaking?
Sure. Mr. Wolf, you swear the testimony you're about to give the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you,
I
sir. You
do.
may lower your
I
hand.
do. Thank you,
Go ahead.
Judge. Regarding some of your questions, the agreement to produce both films was going to be at a huge expense to Throttlebox and its investors. The only collateral that we would have had in the film would be the purchase of the rights and story of REM, which we are attempting to help produce. When the court says that, what difference does it make if she's promoting it? It's only increasing the value. It is the persona that is being presented by Ms. Richardson that is the key. Throttlebox entered into the agreement and was supposed to be the executive producer of REM and has not gotten any of that credit. Okay, the $100 for the story and rights is like in a contract $1 and other valuable consideration. It is payment for those rights in addition to the tens of thousands of dollars that were paid to make sure both films got produced and only one of them did. And that's been running along to the detriment of Throttlebox for 18 months. We started making our objections regarding this in December of 22. We continued to make objection to them using, and they're attached in my affidavit. But at the end of the day, that it is our film, but someone else is getting credit for it is to the detriment of Throttlebox. And if in fact they're about to submit it to other film festivals, if it hasn't been shown, if it hasn't been submitted, then there's the status quo. Don't submit it until we get an opportunity to get a response to our lawsuit. There is no question from the emails that I've submitted that she was supposed to produce to fruition Selena. REM was produced to fruition at our expense. And while the estimated amount for both films was $41,000, it's over $80, $90, or $100,000 that was spent without our control or input based upon how it was produced. So I hope that gives to you an understanding is, why don't we just go let her promote it around the world as her film? That must help us. No, it doesn't. It's kind of like Elon Musk is the head of his company, but it was actually started by two other people. But he's getting all the credit and the wealth. So I hope you understand how allowing it to continue, even by saying, yeah, they're doing it with me too, now doesn't.
Thank you, Mr. Wolf.
Our concern.
So I have provided, so a couple of things. I've given considerably more than an hour, even though we started a smidge late and there were some procedural matters that needed to start first. So a couple of things. Number one, not to do, Madam Court Reporter, you can be off the record for a moment. For those of you, I'm going to apologize in advance that are here for the Conte and Duncan matters. I am being called away to a meeting with the county commissioners that I have to go to. I expect that I will be returning probably in 30 to 45 minutes, but it could be as long as an hour. And so I'm going to ask you to be patient and wait for my return. I'm very sorry for the delay. If there are developments that require you to no longer be here, you're free to share those with Mr. Freehoff. But it is 2:19, and I'm going to ask that everyone return at 3:15 unless you've let Mr. Freehoff know that your issues have been resolved and you no longer need to appear. Again, I'm very sorry for the delay.
Thank you, Your Honor.
Thank you, Mr.
We
Alexander.
understand. We appreciate you accommodating us.
Okay, thank you. And again, I do apologize. Now, going back to the matter that is currently in front of me. Mr. Wolf and Ms. Richardson, I'm certain that y'all could educate me much better about how this industry works, and about how films are marketed and how these matters come to have financial value and to be owned by one entity or another, or co-owned by one entity or another. I don't pretend to know or understand. I suspect that I will know a lot more about it by the end of this lawsuit than I ever have known about it before. But here's what I hear so far. Sorry, Ms. Richardson. I've heard all that I wish to hear from the parties for today. What I hear is that, at least at this preliminary stage, and understanding that the evidence may prove that I am wrong in my understanding at this preliminary stage, I fully acknowledge that. But the evidence that I'm hearing is that Throttlebox's claim to interest in this film is based on a course of dealing and or emails and or the creation of a parole contract or a written contract. But those are all factual issues that will have to be determined by a fact finder that, if a jury's been demanded, isn't me. And beyond that, the purpose of today's hearing, even if I believe Ms. Brown that ultimately there is a likelihood that Throttlebox will succeed on the merits of demonstrating that they have either complete ownership or certainly some equitable interest in this project based on the course of dealing and funding matters of the project itself. Ultimately, what I do not believe that the irreparable injury that might accrue to Throttlebox is so great that the court should prohibit the film from the asset itself. And again, y'all may disagree with my understanding of it in that manner. But that is particularly true where Ms. Richardson has represented that she is willing to give some representation to Throttlebox on her continued efforts. So here's what I'm going to do. I'm going to grant in part the request for interlocutory relief, and I'm going to order two things. Number one, I'm going to say that Ms. Richardson may not assign, sell, loan, whatever other legal term I am not thinking of right now. You may not alienate your right to that movie to the extent that you claim you own that movie, Ms. Richardson, you or any production company that you control. You may not alienate that movie or sell the rights in any way currently during the pendency of this injunctive hearing. Now, that does not mean that you cannot market it or attempt to have it shown or limited, what's the word, publicized. However, to your suggestion, and that's what I'm going to order, is that to the extent that Ms. Richardson intends to continue to market or advertise or attempt to publicize that project, REM, that you can do so, but you have to give equal credit or some acknowledgement that hopefully the parties can discuss and negotiate and agree upon to Throttlebox Entertainment as an entity that potentially has an ownership or other equitable interest in that film or in that project. I'm certain that that does not address everyone's issues, concerns. This order is going to be in place for 30 days until July the 3rd, which I think technically is 29 days. And if you want me, because July the 3rd is a holiday, to allow that order to be in place until July the 7th, which is the following Monday, I can do that. The goal of that order, and Ms. Brown, if you will please provide me with a draft interlocutory order that I can review and edit, if you'll send it to Mr. Freehoff in Word format, so that I can edit it. But again, I'm granting in part the relief requested. And that relief is, I am prohibiting Ms. Richardson or any production company that she owns or controls from alienating, selling, leasing, anything like that, the rights to this project between now and July, whatever. I think we've decided on the 7th. And I am also requiring that Ms. Richardson acknowledge in any and all postings, efforts, other marketing or advertising, including posters, email, social media, anything like that, that you acknowledge the interest that Throttlebox has in the project, at least the putative interest that Throttlebox has in the project. Now, that is the order I'm going to enter, but I'm also going to order the parties to sit down and mediate how you're going to navigate this issue. I suspect if this is a business disagreement, that sitting down and navigating this issue with counsel may actually resolve this case entirely, but certainly it should be able, the parties should be able to make a presentation for any longer term relief. To be clear on the record, I do want to say that the basis for my ruling is that I have concerns about whether or not there is an adequate remedy here for Throttlebox to sue for damages. But that also means I don't want to denigrate the value of the potential damages to anyone. And I don't believe that Throttlebox has demonstrated that the threat of irreparable injury or the threat of irreparable harm is so great that the prohibition that's been requested by Throttlebox is required. That's going to be my ruling. Ms. Brown, understanding that you probably don't agree with it, and Ms. Richardson, you probably don't agree with it either. But if you could draft something that outlines the ruling that I have just made and send it to Mr. Freehoff in Word format so that I can edit it and get it on file for the parties as quickly as possible. Do you understand?
Thank you, Your Honor. I do. I have two clarity requests for the order, and if I could just add one case into the record with regard to those 4 factors. I understand the court's made the ruling, but and I've already given a cite to the court. It's that Federal Defender Program versus Carr case.
Sure.
Just because the court is not required to find absolutely all 4 factors are present. It is a balancing test under that case. And I understand you've made your ruling. My questions of clarity are for the credit to be given to Throttlebox. May we have either equal credit or as executive producer, whereas she was the producer, so that the titles, is there some delineation that is part of the order that is consistent with the agreement, that at least as we know it today, based on the testimony between executive producer and producer roles? Or will you give us guidance on that unless Ms. Richardson and her counsel and us cannot agree for the order? Ms.
Richardson, do you have a response to that request?
Yes, Ms. Brown, that already exists.
Okay.
Throttlebox.
Hang on, stop. I have to leave, so I need this conversation. Forgive me. I don't mean to be dismissive of what are very real, very meaningful legal issues and factual disputes, but I don't think I know enough to answer your question. But I think Ms. Richardson is implying that Throttlebox is already being given credit, at least as a producer or executive producer. But that's why the third element of my order is that the parties sit down, whether it's by Zoom or in person, and agree or advise me why you cannot agree on how my order will be accomplished and implemented in the interim.
Thank you, Your Honor. My last question with regard to your order for prior posts, will you instruct Ms. Richardson to update those prior posts accordingly, consistent with the order you've just given about acknowledging Throttlebox?
To the extent that I understand social media and that things can be re-upped, then yes, I would require, to the extent that that's going to happen, that it be amended to give Throttlebox the credit that I have ordered that they be given temporarily. Again, to be clear, my order does not make any prejudgment as to the actual vindicated right of Throttlebox to that project.
Understood. And I need to ask a question. What is your? Okay, Mr. Wolf is out of town for 30 days, but we will out of the country. So from June 30th to July 20th, but we will make every effort to get with opposing counsel before then, because the court's order is going to expire, I guess, on the 7th. So
that is correct.
All right. Okay. I'm clear. Thank you.
Thank you all. Yes, Ms. Richardson. Yes.
May I just ask for a bond transcript and draft order?
So I don't know what a bond transcript is, but I suspect it's probably something that has to do with California law. What I can tell you is that Ms. Brown is required as an officer of the court that the proposed order she sends to me has to be copied on you so you can see it. And then I will enter an order that outlines what my ruling is. And that is the ruling. Regardless of whatever I've said here today, my written order will be the order that I enter. And it will be copied to you as a service contact in this case. And then you and your attorney, if you retain one, can take whatever action you believe is necessary. Okay?
Thank you, Your Honor.
Thank you. And to those of you who are waiting on me, I apologize. I will be back as quickly as I can.
Thank
We
you, Your
are in
Honor.
recess.
May we
Thank
be
you.
excused?
Thank you, Judge.
Thank you.
Counsel, I apologize for my tardiness. Thank you so much for your patience. Okay, I'm going to give everybody a few minutes to jump back on since nobody had any idea when I'd be coming back. Okay, I see Mr. Alexander, and I know you had a group of individuals. Mr. Alexander, did you have a court reporter, and were you going to have this taken down or no?
We're not going to take it down, Your Honor.
Okay.
And we do have a number of witnesses, and I do appreciate your time, and I want to be as efficient with it as possible.
Okay. Thank you, Mr. Alexander. So who do I have here on behalf of Mariama Diallo?
Good afternoon, Your Honor. It is Attorney Blunt, and my name is Attorney Ian Walker, and we are here on behalf of Mrs. Diallo.
And Attorney Alexander said he didn't want to take it down. We did.
You do want it taken down? Do you have a court reporter?
We communicated with Ms. Hennings, and I believe that she may be available. I'll let her.
Looks like she is.
I am present. Oh, what happened?
All right, we can hear you. Can you hear
There we
us?
go. Yeah, I'm present. I was here for the next hearing, so I can take it down.
That's very
Okay.
kind of you, Ms.
Thank you
Hennings.
so much.
Mr.
you.
Alexander, if they're going to have it taken down, do you want to share and take down?
Absolutely.
Okay.
Thank you. Thank you.
Okay. So I don't know if you can do it by chat or whatever, but if you'll make sure, Mr. Alexander, to provide your information to Ms. Hennings, so she can get that cost. Okay. Now, I'm going to go ahead and just call the case. Ms. Hennings, are you ready?
Yes, I am. If I could have appearances too
Yes,
when we
ma'am.
start. Okay.
Yes, ma'am. This is going to be a hearing in the matter of Fanta Conte. I'm sorry if I mispronounce anyone's names, versus Mariama Diallo, case number 25 CV 007090. This is an emergency hearing that was filed by Mr. Alexander on behalf of his client, Fanta Conte. And I have Mr. Alexander, I'm going to ask you to make an announcement of your presence on behalf of your client, and then I'll ask for one from Attorney Blount.
I'm Harold Alexander with Alexander Law Firm on behalf of plaintiff.
Okay, and who do I have here on behalf of the defendant?
Hi, Your Honor. This is Attorney Sunita Blunt on behalf of my firm, Creative Esquire, and my co-counsel, Attorney Ian Walker.
Okay, thank you very much. And I see that we have a number of individuals here. Mr. Alexander had indicated we have a number of witnesses. I just want to sort of make sure we're all clear to try and be efficient. I'm sure that you will, but just in terms of what we're here for and the issue. Now, very broadly, what I understand the situation to be is that the plaintiff and the defendant both have an interest of some sort. I know there's a dispute about the nature of that interest in a piece of real property. And that I believe the issue is that perhaps plaintiff wishes to alienate that property or sell it, and Ms. Diallo is unwilling to agree. Now, I will start by saying this. I understand the complaint alleges that I'm saying Ms., I don't know if it's Mr. or Ms., I apologize, but defendant Diallo, it alleges that defendant Diallo only has an ownership interest as a trustee.
Yeah.
And I will say that to the extent the court is allowed to take note of its property records, it does at least appear in the Fulton County property records that property is owned jointly by the plaintiff and the defendant. And now, obviously, that's just what the document says. Obviously, there can be evidence to the contrary. But I just wanted to make sure that y'all were aware that was my general understanding. And then, Mr. Alexander, I will hand it over to you and ask, do you want to go ahead and call witnesses, or do you want to make argument first?
I would like for the court to have an overview.
Okay, go ahead, sir.
And I'll tell you what evidence I intend to present.
Yes, sir.
In Miss Fonte and the plaintiff and Miss Diallo, the defendant, are long-term friends. Okay, the evidence is going to show that Miss Diallo introduced Miss Miss Diallo introduced Miss Fonte to Miss Campbell. That's Yolanda Boone Campbell. And the purpose of that introduction was that Miss Conte wanted to purchase a home, and Miss Campbell is a real estate agent. The evidence is going to show that Miss Diallo agreed to co-sign with Miss Fonte in order for her to purchase the residence. The residence is located at 4520 Clement Drive.
Sorry, Mr. Alexander, is there a mortgage?
Yes.
An active mortgage, and Ms. Diallo is a guarantor on that mortgage?
Ms. Diallo did co-sign.
A co-signer, but currently now, not just at the time that the property was purchased.
No, she became a debtor on the mortgage when it was purchased. It's a purchase money mortgage.
Okay.
Okay. And she agreed because Miss Fonte could not qualify for the loan without having somebody else. You're going to hear that testimony. The real estate agent will testify, and also you will hear from the mortgage broker. The evidence will show that the Miss Diallo has not paid a dime for the property, period. And she wasn't obligated to do. She was the only involvement was that she agreed to assist to be a co-signer so Miss Fonte could acquire the property, and Miss Fonte had all the responsibility to make all the payments with regard to purchasing and maintaining the house.
Mr. Alexander, forgive me for interrupting you, but sort of in an effort to, and y'all sat in on a hearing I had a little bit ago, to sort of cut to what are some of the primary issues. So it's always helpful to me to understand the specific nature of the relief that you're requesting, right?
Okay,
So
yeah.
As I read the petition, it seems like maybe there's a sale to be had that Ms. Diallo won't agree to.
Let me cut to the chase.
Yes, sir.
Okay, so Miss Fonte cannot afford to keep the property. Matter of fact, she's been late on mortgage payments, and in fact, if the amount of about $6,000 is not paid in about a week or so, foreclosure proceedings will get started. There is a sale, and in fact, there's been a closing. Okay, it's been a closing, but the closing could not finalize because Miss Diallo has refused to sign a quitclaim deed. I want to point out that she is not listed as a seller. All she has to do is sign a quitclaim deed. And Miss Diallo has actually filed an answer in this case. I don't know if the court is aware of that.
I am able to see it. It's docket number 6 it's document number 6 in my docket.
Okay. And in that, and I can point you to the particular paragraph, she says that she suffered damages and that she wants her name off the mortgage. Okay, so what we really have, we want her name off the mortgage. The way to get a name off the mortgage is to do the sale, sign the quitclaim deed. If this sale is not, if it unravels, because that's what will happen. If it unravels, what will happen is that the property will be foreclosed. Miss Diallo will be damaged with a foreclosure on her record. Miss Fonte is attempting to carry out her fiduciary duty as it relates to Miss Diallo, and Miss Diallo has a fiduciary duty to cooperate in disposing of the property. Also, especially since she says she wants to get her name off. That's the relief we're asking, that we get an order from this court in the context of a restraining order, injunction, that would direct her to just sign the quitclaim deed. And to the extent that she asserts that she has some claims against Miss Fonte or anybody else, she can proceed with those claims. But we're at a point of urgency and emergency right now where we just need to get this sale closed. And
Okay.
and we're
Mr.
prepared.
Alexander, sorry, a couple of questions. You said there was a closing?
Yes.
Okay. And like, when I picture a closing, I'm picturing, a lawyer's conference room with a lawyer, and probably somebody's done a title abstract, and there's somebody making sure that the mortgage company gets satisfied and all that stuff. Is that what you're saying occurred, or is it something different than what I'm imagining?
No, your imagination is correct. And let me just give you some things that will kind of help to clear up how this happened. Okay.
Yes, sir.
Okay. Miss Fonte is the only seller in this closing. Miss Diallo is only being asked to sign a quitclaim deed, so she didn't have to participate as a.
Well, forgive me for interrupting again, Mr.
Okay.
Alexander, but that's actually why I asked the question if there was a closing, because my understanding is she did have to participate, because if she's listed as an owner of record, even if there's a dispute about the nature and extent of her ownership, she has to be included in and authorize the sale of the property. Does she not?
Well, she does, but it can be handled by doing a quitclaim deed.
Or she could quitclaim deed, and then Ms. Conte would own the property in its entirety.
Well, the way that this is structured, she can quitclaim it to Miss Conte, or she can quitclaim it to the purchaser. She doesn't have to make any representation as to her interest in the title. She can, because she alleges, well, as the evidence is going to show to the contrary, she alleges that she never agreed to be on it anyway.
Okay.
So all of her concerns are addressed by simply doing a quitclaim deed.
Okay.
And she can continue, and the fight can go on, and they can prove that it was fraudulent. But the evidence is going to show that when it was purchased, Miss Diallo gave a power of attorney to Miss Conte.
Mm-hmm.
That power of attorney is going to be presented in the record. We have the witness who signed the power of attorney, and I'm looking. The notary was on here earlier, and and the notary is actually on here now, and they will testify that Miss Diallo personally signed the power of attorney, and that will be proven by the notary and the witness.
Okay. The power of attorney to do what?
To give power of attorney to Miss Fonte, so that when the purchase was done in 2020.
So to execute all the documents that went with the purchase.
That's exactly right. And so that's at the crux of Miss Diallo's allegations now. Mm-hmm. And she's really, truth of the matter, she's been coached by some people. As you'll see and hear from the witnesses, both Miss Fonte and Miss Diallo, they are not very they need counsel, and they need people to be assisting them in making transactions.
Okay.
And so you'll see that the allegations that they're making has no basis in fact, that in fact there was a power of attorney that was used for her to be a co-purchaser of the property, and that after some time went by, Miss Diallo start requesting that her name be taken off the property because she said she wants to buy a house of her own. Mm-hmm. And so Miss Fonte, along with Miss Campbell, have tried to facilitate that, and now we actually have a purchase in place, and all we need is a quick claim deed from Miss Diallo. That's what the evidence is going to show, and you believe all the elements of for the TRO would be satisfied. Irreparable harm. Clearly, there's no harm to Miss Diallo, and in fact, she's going to be benefited along with Miss Fonte. And then clearly, this is consistent with the public interest, as well as I can't think of what the third one is, but that one's satisfied too by God's grace.
Okay, thank you, Mr. Alexander, for that summary. Ms. Blount, I'm sorry, Mr. Walker, if you want to give me a brief overview from your perspective.
Yes. So, Ms. Diallo is again, like you stated, friends with Miss Conte. That part is true, and they have known each other for a while. However, Miss Diallo is very limited in her English, and she does not speak or write English very well. So therefore, she and Miss Conte were friends because they are from the same cultural area in country. However, Miss Conte is also limited. So the first claim that he made about her being her power of attorney,
I'm having trouble.
You actually are a little bit muffled. But I mean, I did understand that you were sharing with me that Ms. Diallo has limited English, and that
okay, so you did hear that. Okay, because I don't know why I'm muffled. Can you hear me now?
Just try and speak up a little bit. I can hear you, but you were just a little bit muffled after the point where you said Ms. Diallo has limited English.
Oh, okay. So that is the first point of contest we want to make, and the second one is because of that. That's what I was saying. And furthermore, Ms. Conte is too. So Ms. Diallo has never given her or anyone else power of attorney, and she would also not give it to Ms. Conte because, again, she's limited in her ability to speak English or write it as well. Our answer and our counterclaim, Your Honor, is based on the fact that Ms. Diallo has never given power of attorney to anyone. And
Mr. Alexander, can you mute? Because I think I'm also getting a little bit of interference from you not being muted. Thank you. Go ahead.
She hasn't given anyone power of attorney, as I was stating, and as well as though she was never present for the closing on the original purchase of the home, and she never gave her power of attorney to purchase a home. She does, as Attorney Alexander stated, know Miss Campbell, and Miss Campbell and Miss Fonte and Miss Diallo all did know each other. But they knew Miss Campbell because, as he stated, she's a real estate agent, and they were entrusting her because they were very limited in their ability to speak and read and write English to assist them with certain things. So Miss Campbell had actually access to a lot of Miss Diallo's personal information. When I say personal information, Your Honor, I mean that she had access to her tax documents, driver's license, social security card, and things of that nature. And I know you're like, well, why would someone do that? Well, that's because of her limited ability, she entrusted Miss Campbell to assist her.
Because Can I ask you a favor? Sorry, Ms. Blount, if you just slow down. You're a really fast talker, and I am too. But I know the court reporters get real mad at us if we don't slow down so they can keep up with us. Go ahead.
Okay. And so she entrusted her with these items to assist her with things like, for example, helping her enroll her daughter into school, or helping to renew her license and things like that. So that is why Ms. Campbell had access to these documents. And as you know, these documents are also the same documents that you would use when you're purchasing a home. So Ms. Diallo was not aware and was never going to purchase a home with Ms. Conte. And just to let you know, Your Honor, the house in question is Ms. Campbell's mother's home. So the purchase, the original purchase was to purchase a home from Miss Campbell's mother and father. Miss Diallo never agreed to it. And that lets you just know that how far the situation goes and how intertwined everyone is, to let you know that that is why we're asserting and claiming fraud and identity theft, because Miss Diallo had no reason to assist Miss Campbell with purchasing her mother and father's home for her in this context.
Okay. What of Ms. Blount, Mr. Alexander's representation that Ms. Diallo has said, I don't want to be on this mortgage. And theoretically, if the closing were allowed to go forward, then the mortgage would be satisfied. There would be no outstanding debt on Ms. Diallo, and her name wouldn't be on the property or the mortgage. What of that representation?
And Your Honor, if I can respond to that. Earlier, you asked if Ms. Diallo was listed as a seller of the property. She's not. They're asking her to be a sign up on a quick claim deed. And there's a reason she's not listed as a seller, because she was not originally a purchaser of the home. And essentially what they are asking is for her to assist them in a scheme of purchasing a home that she never agreed to. And
Well,
the reason
forgive me for interrupting, Mr. Walker, but so that's actually why I started this hearing by saying, to the extent that the court is allowed to take judicial notice of its own property records, the Fulton County Superior Court property records say that Ms. Diallo and Ms. Conte own that property together. Now, I don't know if it's jointly with right of survivorship or as tenants in common or whatever, but the property records indicate that they own the property together. And so to my way of thinking, and that was the reason I asked the question, if they own it together, Ms. Conte can only sell what she owns.
Mhm.
And so if she owns the whole property, she can sell the whole property. If she doesn't own the whole property, then she either needs a quick claim deed from Ms. Diallo, or she and Ms. Diallo need to agree to sell the property. Go ahead.
Yeah, I know you're saying you're taking judicial notice. I just want to make clear, obviously, this is an emergency hearing. We were just brought in the last 48 hours.
Of course.
And Ms. Diallo, we are planning on taking future actions on her behalf. We will be filing action to have her removed through means of the declaratory judgment. I know we haven't filed that yet. This was just brought to us within the last 48 hours, but essentially what they have done is they have sold her identity, purchased the property, listing her as a co-signer without her knowledge, and then they want to dictate to her what is the appropriate remedy to seek in this matter. And that's just unjust to think of. To think that I've been victimized of a crime, and the only reason why you now need to include me in selling this property is because I found out about you stealing my identity when I went to go purchase a home on my own. So I understand they want her to sign off on a quick claim deed, but to me, that's unconscionable that someone could steal my identity, purchase a home, and when I find out about it and I'm not okay with it, I'm not okay with signing off with a quick claim deed, you want to file a restraining order and help me assist you in a crime that you committed against me where I'm the victim. I understand that it is in the Fulton County clerk record. I'm not disputing that, but we will be disputing that in the next few days. So what we are saying is it would not be just to force Ms. Diallo to go along with this sale when her identity was stolen in the first place. And I know that we discussed the POA. If you look at her signature on the power of attorney, the person who signed her signature uses the same type of signature that they signed for Ms. Conte on the warranty deed. It's the same handwriting. We have Ms. Diallo's license, and her signature is almost a scribble. If you look at the power of attorney for this purchase, where they forged Ms. Diallo's signature, it's block style handwriting, the same block style handwriting that they signed the warranty deed with. So we don't think that Ms. Diallo being forced to sign a quick claim deed is an appropriate remedy, because essentially they're asking her to go along with a fraudulent sale. It's not for me to speak for her, but again, Ms. Campbell or Ms. Boone, she was helping our client and Ms. Conte because they are of limited means of speaking and writing English. And whoever signed for Ms. Diallo is the same person who signed for Ms. Conte. So we are asking for the temporary restraining order to be denied. That is not in the interest of the public, because a crime has been committed. We have filed a police report, and we are seeking additional measures. This is not the only, and it's not the most reasonable remedy to be enforced. And
let me interrupt you, Mr. Walker. So
yes,
I understand. I think I understand that your client objects to the relief requested, which currently the stated relief requested is to require Ms. Diallo to execute a quitclaim deed alienating her interest in the property, which again, I don't know if it's a divided 1/2 interest or an undivided 1/2 interest, but she definitely, according to the property records, owns half of that property.
Mhm.
And so one question I have is, if Miss Diallo doesn't, if she denies ever having been involved in the purchase, why is it not an appropriate remedy to allow her to no longer be involved in the purchase? And that wouldn't, to my way of thinking, limit Ms. Diallo's ability to, you know, pursue other civil remedies for, hey, you stole my identity, you bought property without my permission, you know, I had to go hire a lawyer, whatever those causes of action are. How does the property going ahead and being sold to somebody else, and specifically, this goes back to an earlier point I made with different litigants, is how does it help anybody for this property to just sit there and not be sold and go into foreclosure? Because we all know what's, you know, if the house is worth $100,000 on the open market with a seller, it's going to be worth less than half of that as a foreclosure. So how does that benefit anybody?
Yeah.
Yes. No, it was a question. I would love an answer. Only thing I will say, just technically, there's two of you, and I'm sure Mr. Alexander is quite capable of holding his own, but usually it's one lawyer for an issue. But as long as Mr. Alexander's okay with it, I will let you go ahead.
Okay, it looks like he's saying he's okay.
Yeah, Mr. Alexander's muted, but he's looking like he's okay with it. Go ahead,
Okay.
Ms. Blau.
No, I was going to say, to answer that, Your Honor, the reason why we're saying that's appropriate, because basically, if she now signs off on the sale, that means that she's ultimately saying, like you said, that she was an original legal owner. And our argument is that
Hang on, you're muted and going so fast. So I think I understood you to be saying that if Ms. Diallo signs off on the quitclaim deed, you're concerned that what she's saying is
that she was an original legal owner of this property, and her and Ms. Diallo's concern is that she's not an original legal owner. So why would she then sell something? And then I get what you're saying, that afterwards she can, you know, seek any remedy she wants. But
is she seeking a share of the proceeds of the sale?
No, Your Honor, she's not. And
Okay.
part of our position is it's almost unconscionable for someone to steal your identity and then file a restraining order against you to help them almost have you forced to sign off on the sale of the property and almost facilitate them in completing a crime. She did not, she's not seeking a financial interest.
she actually doesn't even know any of the interest in the property. That's what we're trying to reiterate. She has no.
But if you could use my identity to purchase a piece of property, and I'm sure they're selling this piece of property at a gain, or they are benefiting from the sale of it, for you to use my identity, use my credit profile to secure this mortgage, because you clearly cannot do it on your own, and then file a restraining order against me, asking that I be required to sign off on the sale because I found out about this identity fraud and theft where you use my identity. So you can gain monetary gain, financial benefit. To me, that's unconscionable. And I understand there's a quitclaim deed is you signing over any interest that you may or may not have, but to assist somebody in completing a crime, and to me, this is a crime, a police report has been filed. You stole my identity to purchase this property, and then you're attempting to sell this property as a gain, and then you want me to sign off on the sale. It's almost like, it's, to me, that's asking me to help you complete a crime where I'm the original victim of, and saying, well, it's in your best interest. You know, you're listed as an owner of this property. Don't you want this property to be off your record? Well, of course I wanted to be off my name and off my credit profile, but I'm not going to help you complete a crime that was taken against me. You stole my identity without my authority. So that's our position. I don't think that's in the interest of the public. I don't think that's in the interest of justice. To me, it's almost unconscionable.
Well,
our client, I'm sorry, go ahead.
Mr. Walker, I don't disagree with you that if half of what you say is what actually occurred, that all sounds really bad. And Ms. Diallo probably has a number of methods of legal recourse, potentially. But what I'm trying to get to the bottom of, because keep in mind, I know you guys all want to convince me of the righteousness of your position legally and factually. But the only thing I'm concerned with right now today is whether or not the status quo is to allow the sale of this house to go through. And again, you know, there are the factors that the court has to consider, but ultimately the issue on an emergency request for relief in this circumstance is whether or not we are maintaining the status quo. Now, presumably the easy option here is you can't sell the house because that's status quo. right? Right now, the status quo is Ms. Conte and Ms. Diallo own the house. But what I'm not understanding is from Ms. Diallo's perspective is if she doesn't agree to let the sale go through in some form, however she might agree to let that go through, as long as she reserves whatever claims she might want to raise, then the house, there won't be anything left to fight about, right? So currently, Ms. Diallo is a guarantor on a mortgage that she claims she didn't agree to. And currently, she is on, she owns a piece of property that I believe I understood you to say she doesn't want any of the proceeds of the sale. And I can't give anybody legal advice, but a quitclaim deed doesn't say I personally have an interest. It basically says, to the extent I do have any interest, I hereby quitclaim it. I'm like, I don't want anything. And it sounds like, short of legally executing such a document, that's essentially what y'all are saying. Ms. Diallo wants no part of this, subject to her claims against Ms. Conte and perhaps others that they stole her identity and used that information to guarantee her on a mortgage. Am I understanding that correctly, Mr. Walker, Ms. Blount?
That is correct, Your Honor. And as the court stated, well, it's our position that there are other remedies available. I know that signing off on a quitclaim deed is one of the available ones. That's not the remedy that we're going to be seeking. We will be filing an action against the mortgage company, Ms. Conte, Ms. Boone Campbell, and all other parties involved, seeking declaratory judgment to take her off of this contract, this mortgage contract. Because as we all know, fraudulent signature makes a contract unenforceable. And it is our desire not to sign the quitclaim, because it's our position. If you have defrauded me, stole my identity, purchased the property in my name, and then you come to me wanting to help you assist in the sale so you could get financial gain, is unimaginable. So I understand that quitclaim deed can remove Ms. Diallo from the property, and that's not an acknowledgement that she owns the property. But to me, that's almost unconscionable to order somebody to sign off on a quitclaim deed to allow people who have stolen her identity to have financial gain from the identity fraud that occurred. I know I used to be a prosecutor, and there is a police report that has been filed, and we are seeking charges. And I do think that's something that a juror would take into consideration, and perhaps even the state would take into consideration. I know that this is a civil matter and not a criminal matter at this juncture. We are seeking charges to be filed. We have talking with individuals at Atlanta Police Department that are looking into this. And I'm not only thinking from a civil perspective, but also from a criminal perspective. If I was a prosecutor, that is something I would take a look at, the fact that she signed a quitclaim deed to help facilitate in the sale. I understand that you say that doesn't preclude her from any other remedies, but I'm not going to say it's the appearance of impropriety, but that's something that a juror could take a look at and would have to consider, and it's something that the state would have to take a look at. And to ask somebody to facilitate and sell a property where they were defrauded to help somebody gain financial gain in the sale of the property, I understand that that is one course that can be provided as a remedy to all parties involved, but that is not the most appropriate course that we think is appropriate. And like I said, we were just involved in the last 48 hours, that we will be seeking a declaratory judgment to remove her from this property, remove her from this mortgage application, and we are seeking criminal charges. And once our client is removed from this,
I understand. Forgive me for interrupting you, Mr. Walker. I understand all that, but what I'm struggling to reconcile here is you're going to sue for declaratory judgment to get me to declare that she should be removed from the mortgage and removed from the property, or you could sign a quitclaim deed that accomplishes the same thing without the need to file a declaratory judgment. That's the part I'm struggling with. Now, I do have concerns that ordering someone to sign a quitclaim deed is an extreme remedy. I'm gonna interrupt for a moment, Mr. Walker, and ask Mr. Alexander, I have a couple of questions. Who is the seller? Is it just Ms. Conte? You're muted, Mr. Alexander. Thank you.
I apologize.
It wouldn't be a Zoom hearing if I didn't have to say that at least once. So
okay. Now you're absolutely correct. It's only Ms. Conte, and allow me to point out that closing disclosure is attached to the complaint. I believe it's Exhibit 3. And I'd
Yes,
like
sir.
to also point out that it's good that the court got judicial notice, but we also attached the deed to as Exhibit 1 in the complaint. It was a limited warranty deed, and it's attached as Exhibit 1 in the
And
complaint.
it is joint tenancy with right of survivorship, which means they
Yes.
each hold an undivided 1/2 interest.
Yes, yes. So, Your Honor, we're giving all disclosure on here. This is the and as if you hear evidence on this, some people got Ms. Diallo and tell him she needs to enter into all this extensive litigation, and there's some other people involved also. Okay, and really what it is really an effort to try to get some money. Okay, but it's nothing gonna. Everybody's gonna be hurt if the court does not order this sale to be able to be finalized simply with a quit claim deed. And as you stated, what the nature of the quit claim deed, and it's really good that it was structured this way, is because Ms. Diallo makes no representations as to what interest in it at all, period. And we're prepared to present the facts to show that to the extent that, and I'm only trying to deal with the TRO. I'm not.
No, and I appreciate that, Mr. Alexander. Forgive me for interrupting you, but the reason I'm sort of is just as I did with the prior hearing. I have no concerns that if Ms. Conte were called as a witness, that she would testify largely as you have proffered.
Yeah.
That if Ms. Boone Campbell were called as a witness, that she would testify largely as you have proffered. If the notary were called as a witness, that she would testify largely as everyone has proffered.
Yes.
And so what, to me, the issue is, again, I know what the factors are, and I know that all of them don't have to be satisfied, but what really concerns me here is it feels like you might be entitled to some relief in terms of the ability to sell the property, because I don't want, but ordering someone to file a quitclaim deed is a very extreme remedy. And so one of the things I'm struggling with now is, let's say I think that you could satisfy the elements to my satisfaction, that you're entitled to some type of injunctive relief. What I'm trying to do is craft or think of some type of relief that would accomplish what I want to accomplish, which is to avoid the foreclosure, to allow the property to
be sold.
Thank you. Without prejudicing the rights of any party going forward to pursue their causes of action. I mean, one thought I had is if I were to order the proceeds of the sale to be paid into the registry of the court, but that doesn't even seem like it's necessary because Mr. Blount and Ms. Walker, or, I'm sorry, Ms. Blount and Mr. Walker have not said that they're making a claim to the proceeds of the sale.
Yeah.
The sale would accomplish the getting rid of Ms. Diallo's legal obligation on a mortgage.
Yes.
And the sale would not, I don't believe, it would not foreclose, pun intended, the ability of Ms. Diallo to pursue a claim for damages for fraud or anything else that she might be attempting to pursue.
Your Honor,
I guess, Your Honor, our issue is...
Your Honor,
hang on. I did call him Mr. Alexander, so I'm gonna let him answer, and then I'll hear from you, Ms. Walker.
My clients are willing to actually put in the quitclaim deed that any claims that Ms. Diallo may have against Ms. Fonte or anybody else in the world, that the quitclaim deed does not prejudice those claims. So we're completely willing to accommodate every concern that they've had, that they have, and I would hope that the court could see that with that everybody's interest would be protected, we could literally put in the quitclaim deed to the extent that Miss Diallo has any claims against Miss Fonte or anyone else, we can say literally in the world, with regards to this property, 4520 Clement Drive, that this quitclaim deed does not in any way release or prejudice in any way her right to pursue those claims. I don't understand why that wouldn't address the concerns that are being raised by counsel.
Ms. Walker? I'm sorry, Ms. Blount?
I guess, Your Honor, one of our issues is just like how you stated earlier, you stated that they own the property in joint tenancy. One, that would be kind of unjust because then the court would be forcing a co-owner or a joint owner, forcing them into a sale. And as you know, when they have rights, they have rights and to either not sell or sell the property. And as we stated, obviously, Ms. Diallo is stating that these rights aren't even technically hers because she legally didn't sign off on it. And the second thing is, outside of that, this is a TRO, but if they wanted her to force her, why didn't they file a partition action? And that was the case.
I mean, they certainly could file a partition action, but what I'm struggling to figure out how Luder Larkin was even able to have a closing.
Right, because Miss Diallo was, then that's nothing. That's why I'm saying that's how you know that it was something fraudulent happening. Miss Diallo was not aware of the closing. She was not told about the closing. She knows nothing about the financial benefits of the house. She knows nothing about the equity in the house.
No, that wasn't, forgive me, Ms. Blount, but that wasn't my point. My point was Luder Larkin is a reputable law firm that routinely does real estate closings. And so I'm struggling to understand.
They attempted to have a closing, and our client, Ms. Diallo, she's here with her pastor and her first lady. And when her first lady, Miss Wanda called, I believe the closing, what she called the real estate agent, it was made known to her that they attempted to have the closing. Miss Diallo was the only person that was not present. I believe some funds had already been transferred, and they said they were going to have to rescind. I don't know if I'm using the proper language, but they were going to have to rescind the closing because Miss Diallo was not present and she did not sign off on it. And then that's part of the reason. That is the reason why they filed this emergency TPO hearing, because if they didn't get it, the closing finalized in X amount of days, they were going to be out of money because they did go to execute the closing. And somehow or another, they were able to send the funds without Ms. Diallo's signature or signing off on it. And the mortgage company said they were going to send the money back if Ms. Diallo did not sign off in X amount of days.
And they contacted her after
the fact.
And that's when she found out about
it. That's not true, but the point is,
we have it in the text message from
Stop. Don't talk to each other.
I apologize.
Talk to me, Mr. Alexander.
Okay, Your Honor, it is true that, as I stated, the closing was done with Miss Fonte being the only seller, and that the way that Miss Diallo's interest would be dealt with was going to be by the quitclaim deed. And so that's the way that it was structured. Now, what I was saying that it's not true is that it's not true that Miss Diallo did not know about the sale, and all the evidence will show that, except for this quitclaim deed, everybody's concerns would be addressed with the quitclaim deed. Everybody's concerns would be addressed, and as I stated, we're willing to even put in the quitclaim deed that that any claims that Miss Diallo wants to pursue, those are reserved. So if the court does not grant this petition, everybody's just going to be devastated. It is true. As a matter of fact, I have, as part of the evidence that will be introduced, and I've already filed it, is that the funds from the mortgage company has actually been returned. Okay, now we have as a witness here the mortgage agent, Miss Hicks, And so all of those matters can be addressed, but everything comes around back to the same point about, okay, if Ms. Diallo is suffering and don't want to continue to suffer, get her name off this title that she says she's not supposed to be on, and preserve her rights to pursue all the grievous actions that the council has caused her to believe that she has, and then we get past this, and then we can fight about who has rights and who has wrongs, and that's why I respectfully brought this matter before the court. Both parties actually are in desperate need of this matter being.
So I think as I have made it clear, and I appreciate you fine folks that have waited so patiently on this Zoom. But as I said, I feel like it is better for me to accept as proffers what the parties have indicated the witnesses would say. Here is where we're going to leave it for today. I understand Ms. Diallo's counsel to have said that Ms. Diallo is not interested in claiming a portion of the proceeds of the sale of this property. Did I understand that correctly?
Yes, correct, Your Honor.
Okay. So I do not wish to deprive somebody who is a rightful owner of a piece of property from their right to own it or from their right to benefit from owning it. But if the defendant does not assert that she is entitled to a portion of the proceeds, and the defendant doesn't want to be on the mortgage, then where I'm leaning is toward providing some measure of relief to the plaintiff. I haven't quite figured out what that relief is going to look like. I want to do some research because, again, what is really giving me pause is my concern that under the circumstances, that the ordering of a quit claim deed execution, that what's been offered by Mr. Alexander's counsel to allow that quit claim to be framed in any way that would be possible in the way of essentially a settlement or release document so that Ms. Diallo would reserve any right that she might have. That is still a pretty extreme remedy. And so I want to do a little bit of research to make sure I'm comfortable with that issue. Now, I will have an answer for you by Friday because I understand that these issues are very time sensitive as to whether I'm going to grant injunctive relief, and that if that injunctive relief is going to be that Ms. Diallo will need to execute that quit claim deed and what that looks like. But that's what I'm going to do. I'm going to take under advisement. To be clear, for the record, I believe that Mr. Alexander's client has demonstrated a potential likelihood of success on the merits. And mostly what I'm persuaded by is that Mr. Alexander, I think, has demonstrated the irreparable harm that might result to everyone. And that irreparable harm exceeds the potential harm that might be that's the part I want to look at, is to make sure I'm comfortable with ordering somebody to execute a quitclaim deed on a piece of property they own is not a greater burden on Ms. Diallo than not granting it would be on Ms. Conte. But I will say this, what is most significant to me is the very real irreparable harm that will inure to everyone if this property goes into foreclosure. And so that's what I'm going to take under advisement. But I do believe that the plaintiff has satisfied the general, has satisfied me, particularly on the issue of irreparable harm, on the issue of the possibility of success on the merits. And the main issue I'm going to look at is if the relief that I would offer outweighs the potential burden to Ms. Diallo. And that's what I'm going to take under advisement. And then I will give you, it may be sooner, it may be tomorrow, but I will definitely give you an answer by Friday so that the parties will be able to act accordingly, appeal or go forward with the closing or whatever it is anybody decides to do. Mr. Alexander?
Thank you, Your Honor. I just want to make point out one other thing. In addition to the notary being ready to testify and the unofficial witness, there's a witness by the name of Tina Gari, who is long-term friends of both plaintiff and the defendant. Matter of fact, the defendant actually works for the plaintiff. And this Ms. Sangari is prepared to testify that that Ms. Diallo has known from the beginning about being put on the mortgage. She's prepared to testify that she has personal knowledge of the conversations and the introduction of Miss Fonte to Miss Campbell, and that she has they're all from West Africa, and that she has personal knowledge that uh, Miss Diallo consented to be on the mortgage, and the whole thing is that her testimony was going to be that Miss Fonte and Miss Diallo, neither one of them could qualify for a house by themselves. That Miss Diallo would help Miss Conte, and then and the plan was to get it refinanced and then be able to get Miss Diallo off, and then Miss Fonte would try to help. And
Mr.
so,
Alexander, I'm sorry to interrupt you. Due respect. I know you're trying to make sure that you have a proffer on the record on that issue. You do?
That's all. That's
okay.
all.
Thank you.
And Your Honor,
Ms. Blount, Mr. Walker, did you have anything to add regarding that issue?
briefly, Your Honor, and we understand that you're saying that this is a potential remedy to please or to make all parties whole, but we just want to make note that this is not only a civil issue. We have found a fish court, and it's also a criminal issue, and that's part of the reason why we would take issue with not consent to signing a quitclaim deed, because essentially that would be making her complicit in a crime that was committed against her. So I understand that you're not looking at it from that aspect necessarily, but we are looking for fresh charges. We have filed a fish report. And in addition to that, we have Mr. and Mrs. Kimbrough, who are our clients at first. I mean, her pastor and her first lady, who also have contact and communication with most of the witnesses that Attorney Alexander mentioned. So we want to make it clear to the court that we're ready to fire our witnesses as well. And again, as this court did take note to, ordering to have Ms. Diallo sign a quitclaim deed is a very extreme measure. And we will ask that you not order that. We understand your position, that is our position. And the fact of the matter is,
do you have, Mr. Walker, a suggested remedy? If my concern is that there is an irreparable harm that inures here, if the property goes into foreclosure, do you have a suggestion for a remedy that might be sufficient to maintain the status quo for now without allowing, to avoid the harm that I'm concerned about?
Maybe the court could issue a declaratory judgment stating that she's not a proper co-signer to this mortgage that was taken out in her name. Declare her not a proper party to the mortgage application or the mortgage contract.
Well, the problem with that, Mr. Walker, is that is a legal declaration that the court would have to make after a full and complete opportunity for discovery and a full trial and a finding of facts that might even be the underlying facts found by a jury, and then the court making legal findings based on those factual findings. And that doesn't solve or avoid the concern I have about the irreparable harm of the property going into foreclosure.
And I understand that, but for her identity to be stolen, and then they don't want their credit to be hurt, because I believe the property went into foreclosure again, and that's why they're trying in a rush to sell the property. But our client's credit has already been damaged. They have missed several mortgage payments. I know this is not in the pleadings, but they also opened up a credit card in her name, and they ran a credit card.
That's not in front of me. Just as I said to Mr. Alexander, I'm perfectly willing to accept your proffer as an officer of the court that you believe you could offer your witnesses to testify to these facts, that there was some wrongful behavior in gaining Ms. Diallo's signature. That's not my issue for today. My issue is, in terms of the elements that the court has to apply, I have real concerns that there is an irreparable harm here that should be avoided. And go ahead.
The court will order that the plaintiff refinance the property on her own. I understand that takes time, but if they're alleging that was the game plan from the beginning, why has that not occurred? They want her to sign up on this quitclaim deed because she found out about it and she wasn't supposed to. She doesn't even own a home in her own name. Why would she help somebody else buy a home when she doesn't own a home? Like, and then they want to force her to help them sell the home. And the court's going to take judicial. Hold on. If the court's going to take judicial notice that she is the rightful owner of this property, perhaps we do want some type of interest. Because I believe the house is like $200,000 or $300,000. So if that's respectfully, if that's the position that the court is going to take, the judicial notice, yes, we do want an interest in the property because you have ruined her credit. You have used her credit to secure this mortgage that you cannot secure on your own. And then when she found out about it, you want her to sign up on the sale to help you facilitate and make a financial gain at her detriment. Her credit has been ruined. They have already missed several mortgage payments that's currently on her credit report. And so if the court is going to take judicial notice that she's the rightful owner, yes, we do want an interest in the property because she has attorney fees. She has to pay money to clear her credit and clear her credit up. And she wants to buy a home of her own. So she's in an even worse position than she was to begin with. And she's not going to be able to buy a home because she's in a worse position than she was to begin with on something that she never gave the okay or the authorization to. So if that's the position the court is taking, we do want.
Okay. I understand your position, Mr. Walker. Let me go back one moment. Mr. Alexander, you provided me Exhibit 3 is the good faith estimate, or is it maybe the actual closing settlement statement? Is the total cash out of this transaction $4,901.56?
Yes.
Okay.
Okay. I think that needs to be looked into as well because there's 2 payments coming from the documents on the closing to revocable trust. So I think that it's like a significant amount. I think it might be over 6 figures. So I don't want to say anything out of line, but it's highly suspect that over 6 figures out of the sale is being transferred to an irrevocable trust that we believe that.
May I address that, Your Honor?
Briefly, yes, sir.
Okay. They have filed a counterclaim.
I understand. And that's not, nope. Here's what I thought you were saying, and this is what I want you to address is what is the revocable trust? There are 2, he's right. The settlement statement has 2 payments of about $70,000 going to 2 revocable trusts.
The revocable trust is a trust that actually is associated with Miss Campbell's family. Okay. All right. They have actually been assisting Miss Fonte in keeping the house from being foreclosed. They've actually been paying the mortgage payments to keep it from being foreclosed as she was trying to find somebody to purchase the home. So we're willing to have all of those issues to be addressed. If there's some claim that should be made against anybody, including Miss Campbell, we're willing for all those claims to be heard from the court. We're just saying, let's not allow the baby to die. Okay. Let's try to save the baby. And then anybody that's harmed the baby or never should have done what happened to the baby may be in this condition or other condition. Let's save the baby. And then whoever needs to be, if there's some problems about the baby, let the court deal with that. If there's some liability, and I believe if we get to that point, the truth of the matter is the evidence is going to show that Miss Fonte has been assisted by not losing the house before.
No, that's fine. Again, it's not an invitation to get down into the weeds again.
That's it.
The reason I asked the question is this. I'm going to ask a couple of very clear, I hope yes or no questions.
Yes.
The payments to the BB&T revocable or the Truist revocable trust, whatever they were, have they already been made? And are they in danger of being clawed back? Are they still held by the mortgage, by the whoever?
The payments have not been made.
Okay. The reason I was asking is that one of the things I was considering, haven't decided if that's what I'm going to do, but one of the things I was considering is allow the sale to go forward, but require the proceeds of the sale to be made into the registry of the court. And then we can find out who's entitled to those proceeds. That's just something that I'm flirting with to, again, avoid, to borrow your metaphor, Mr. Alexander, to avoid the foreclosure, right? To avoid the baby dying.
Yeah.
And so that's why I was asking.
Yes, Your Honor.
Okay. I have everything that I need. I am going to issue a ruling between now and Friday as to what my ruling will be. But as I said, just in the interest of full disclosure, so everybody has an expectation, I am concerned that there is an irreparable harm and that Ms. Conte has sufficiently demonstrated that potential for irreparable harm, and that there is a potential for success, a likelihood of success on the merits, and that those factors to me weigh in favor of considering whether or not to give some interlocutory relief as was requested, but I'm going to figure out what relief that's going to be. Once I do, of course, everyone can take any action they wish to take based on my ruling. Okay. Yes, ma'am.
Quick question.
Mhm.
Depending on your ruling, we would also like to suggest that depending on what you rule, if you do rule against us, can the proceeds be put into escrow until everything else has been adjudicated?
That's actually what I just said, is that one of the things I was considering is requiring the proceeds of the sale to be paid into the registry of the court, and then I would hold those proceeds until the parties figure out who they belong to.
Okay.
And not just the $4,000, the full amount that they were attempting to send to the revocable trust that.
We would like that to be going there too.
The proceeds of the sale are everything after the mortgage is satisfied. Okay. And so that would be all of it potentially. That's what I'm considering. I haven't said that's what I'm going to do, but that's what I'm considering.
Thank you for clarifying.
Your Honor, I would just ask that you allow the closing attorneys, those closing costs to be paid also at a minimum.
Yes. And again, for people who don't have a dog in this fight, I'm not trying to be overly punitive to them as well.
Right.
So anyway, I think what I need. And I will act accordingly in that regard. Separate question. It can sometimes be clunky to pay it into the registry of the court. Yeah. If the court were inclined to be concerned about maintaining the funds from the sale while the mortgage gets paid off, if I were to go that route, would anybody have a problem with directing Luter Larkin to maintain it in their escrow?
Yes, we would, Your Honor.
Is that the closing?
Okay. Sorry, let me be clear. Mr. Alexander, would you have a problem with me ordering Luter Larkin to hold it in their escrow?
Absolutely not.
Okay. Ms. Blount, Mr. Walker, that is the closing attorney. Okay. Keep in mind, I understand that you have strong feelings about what may have occurred here, but you should always be this is just a judge giving you personal advice. You should always be very cautious about asserting what it sounds like you're asserting is that at a reputable, well-known law firm like Luter Larkin is not going to follow an order of this court to hold nearly $100,000 in escrow if I order them to do so.
We understand, Your Honor. You just have to understand our position because we feel like the closing, as Attorney Alexander already stated, the funds have been sent back. And it seems as though a closing or a form of a closing has already occurred without Ms.
Clearly
Diallo.
It did. That's why the settlement document exists.
Yeah, correct. But the fact that they got that far without Ms. Diallo gives the defense concern. So that's why we have position that
which is concerned. We are not saying anything against Luter Larkin. I don't know him.
Okay. Thank you all for your time, especially those of you who waited so patiently that I did not actually call on to testify. I do appreciate your presence here and your willingness to testify. You are all free to be excused. Thank you for your time today.
Thank you, Your Honor.
Thank you.
Thank you, Mr. Alexander, Mr. Walker, Ms. Blount.
Thank you.
Thank you, Your Honor.
Counsel who's here on the Duncan matter, if you can give me 5 minutes, you will then have my undivided attention. Thank you all. Good afternoon, everyone.
Good afternoon, Your Honor.
I really appreciate everybody's time. I'm
afternoon.
very sorry for the delay. It's been quite a day.
Understood.
So I appreciate your patience as I worked through. It's just so happens that we have 3 emergency hearings in one day, and then when the Board of Commissioners calls, you have to go answer. So I apologize for that interruption, but I do appreciate your patience. I know that you have a court reporter, Ms. Hennings, so I'm going to just call the case, and we can already go on record. This is going to be a hearing for a TRO or other emergency relief in the matter of Rebecca Duncan versus Justin Hackney and JMH Property Holdings LLC, case number 25 CV 007234. If I could get an announcement for from counsel for the starting with counsel for the plaintiff.
Good afternoon, Your Honor. Josh Belinfante and Javier Prats of the Robbins firm for Ms. Duncan.
Okay. And for the
Bill,
defense?
Bill Piercy on behalf of the defendants. I'm with Berman Fink Van Horn.
Okay. Thank you. Now, I'm going to tell you what I think I know about your case, which is very little, but I have at least reviewed the pleadings. I know I have received a number of additional documents over the course of yesterday and today in advance of this proceeding. What I understand very generally is that Ms. Duncan and Mr. Hackney used to be in both a relationship as well as a business relationship, and that the allegation is that there had been some agreements back and forth about purchases of various assets that either have been sold or are on the verge of being sold, and that there is a dispute that has now arisen between Ms. Duncan and Mr. Hackney, and presumably Mr. Hackney's company, JMH Property Holdings, as to who controls and who controls the assets and who's entitled to payment for those assets. That's what I generally think I understand. Anything I just said that's wrong, please correct me, Mr. Belinfante. And with that, I will throw it over to you to go ahead but as you probably gathered from my other hearings, I of course will hear from witnesses if I need to, but to the extent that there have been affidavits or other representations that have been made, I'm happy to accept proffers from the lawyers about what you believe the facts will show. And as I think you definitely can tell, to the extent that you can hone in on the nature of the relief that you are seeking, because ultimately the harm is always going to have to be balanced against the nature of the relief that's sought. And if the relief isn't tailored to maintaining the status quo at this procedural posture, then we're all I don't think I'm doing my job if that's not what I'm doing. So with that, Mr. Belinfante.
Thank you, Your Honor. We have Ms. Duncan here. I agree with you that there's probably not a need for her testimony given the pretty lengthy verified complaint. To just point out a few things in response to the court's question. The relief we're seeking today is that the proceeds of the sale of what we refer to as the Fulton County property, which is the 2863 Sterling Ridge Court in Alpharetta, be placed into the registry of the court. We would not object given what the court said about it being, bulky or sometimes difficult to do, having it be in an escrow account for one of the law firms present today. We did initially, just to clarify, suggest that the sale should not go through, and we were considering, and we had at least asked the court for that as a possible remedy. Given that Mr. Hackney has counsel and he's here today, we're not seeking that. That was in case we could not get a response or an answer, or if it was done on an ex parte basis. With that, I will hand it over to Mr. Prats, who will kind of walk through our opening position. I'll come back to kind of sum things up, or if Mr. Hackney is called to testify to cross-examine him.
Okay, thank you very much. Mr. Prats?
Hey, good afternoon, Your Honor.
Good afternoon.
Okay, see if that works. Yeah, sorry about that. Just waiting until Josh was muted.
Technology, yep.
Yes, ma'am. So, Your Honor, we're here on a very limited question today, and that's does the balance of the equities warrant putting the proceeds of the Fulton County property sale into the court registry? as Mr. Belafonte said, we're not here to stop the sale, and we're not here for the court to resolve any dispute or questions in fact. Looking at the verified complaint and the response provided by defendants, it's undisputed that Ms. Duncan paid for everything for the Fulton County property, as well as the investment properties. As stated by the Supreme Court of Georgia and Rollin v. Martin, a verified complaint serves as both pleading and evidence and may serve as a functional equivalent of an affidavit. As defendants stated in their response, Mr. Hackney expects to receive $355,704.03 from the sale proceeds of the Fulton County property. That would not be possible without Ms. Duncan's contributions, and equity means something. The main question relevant here is whether the possibility of recovering money damages is dispositive. The answer is no. An interlocutory injunction is justified if a legal judgment is practically meaningless. That can be seen from Kinnard v. Ryman Farm Homeowners Association, Inc., Georgia Supreme Court case found in our brief, as well as if there is a shown risk of insolvency. And that also justifies an injunction as seen in Mitchell v. Hayden Stone, Inc. That's another Georgia Supreme Court case. And the Supreme Court of Georgia has approved of such injunctions where the potentially frozen assets would be needed to pay any judgment. That can be seen in Kennedy v. W.M. Shepherd Lumber Co., Inc., another Georgia Supreme Court case. As a brief overview of the parties, they began the relationship in late 2019. In April 2023, they decided to purchase a home, the Fulton County property. They closed on the home in June of 2023, and then they were engaged in late 2023. Regarding the Fulton County property, as mentioned before, the money used to purchase the property, $559,860, all came from Ms. Duncan. Ms. Duncan also provided all of the mortgage payments from August 2023 till February 2025. The money was provided as a gift. Defendants mentioned that, and they provided that as an exhibit, and that was an agreement then. However, a new agreement was entered when the couple was separated in late 2024, and that can be found in paragraph 33 of the verified complaint. In that agreement, Mr. Hackney agreed to sell the house on both of their behalf, and would provide Ms. Duncan with all of the proceeds from the sale of the house, and he would not receive any commission. Now, going through
Mr. Pratt, let me interrupt you for a second and ask you a couple of questions. So, as I understand the complaint, there are stated concerns about multiple other, it's not just this property and the proceeds from this property, right? There are multiple other business agreements or arrangements where Ms. Duncan alleges that she funded those arrangements and hasn't seen the benefit of them. Is that accurate?
That is accurate, Your Honor.
Okay. And so, how does that affect so in one bucket, you're talking about a unique asset that Ms. Duncan claims an equitable interest in. It has been sold. There are proceeds that are clearly identifiable as being tied to that property. Not a super far stretch, depending on the relative merits of the case, et cetera, that we can identify those proceeds and keep them in, and hold on to them until we figure out what we're doing. How does that, though, relate to if this is really about a large group of other potential asset transactions that were made, that Ms. Duncan is essentially trying to hold on to these proceeds in order to be able to recover them, even though she might only be entitled to a portion of the proceeds from the sale of the house at Sterling Ridge?
We're talking about just the Fulton County property in this motion, Your Honor, and that's because it's just on the verge of sale, whereas the other ones are not.
Okay.
We know that where this money is going to be. We know the sale is pending. The other ones, there's only been one property that was sold, and that was the Sugar Hill property, and that was for $560,000. But again, that money, we don't have access to that money anymore because Mr. Hackney has it. Whereas as the sale is happening right now, we're trying to get that money into the court registry for that reason.
Okay. You can continue. Thank you.
Yes, ma'am. And so for the temporary restraining order, there are 4 prongs. And the first is if there's a substantial threat that a moving party will suffer irreparable injury if the injunction is not granted. And the facts shown in verified complaint show a likelihood of immediate irreparable harm. First, Mr. Hackney's conduct to date indicates that he won't repay Ms. Duncan, as he hasn't repaid her to date. And that can be seen from Jonesboro transaction, whereas Ms. Duncan provided Mr. Hackney $110,000, later found out that it was only purchased for $55,000, and the other $55,000 was not returned to Ms. Duncan, also after she demanded it at various times. And then there was a Sugar Hill property that was previously mentioned that Ms. Duncan paid for the entire property for $310,370, and it sold for $560,000. And Mr. Hackney did not put any personal money into that purchase, and Ms. Duncan has not received any money from that. Or Mr. Hackney cannot repay the debts that he sold because he's insolvent. For instance,
but I guess going back sort of to my original question. So, I mean, generally speaking, there is, I mean, the case law generally says that you're not entitled to equitable relief if you have an adequate remedy at law. And I believe that there's case law that says that insolvency or the risk of insolvency, when really what you're talking about is recovering on a subsequent money judgment, isn't a reason to enjoin certain funds. Now, going back again to my question, I understand if it was just this asset and just the proceeds of this asset. But if you're talking about a larger ongoing issue where really what we have is a claim by Ms. Duncan for breach of contract or, something, interference with property rights, something, whatever that is, why are those not legal claims that can be satisfied by any funds? Why do these funds need to be impounded? And if I am impounding them, why is that not just in an effort to avoid your inability to recover on any judgment you might recover later?
Well, Your Honor, that can be found from the Georgia Supreme Court case, Alira Healthcare, where a judgment can be practically meaningless. So let's say we get through the whole case and we receive a judgment, but if he doesn't have money anymore, and because then it would be practically meaningless. Because there are insolvency questions here that I'm about to get to, that is why this particular sale is of import right now.
Okay, so your position is that with particular evidence of the risk of insolvency, that there could be a justification for the court to impound these particular funds.
Because of the substantial risk that would irreparably harm Ms. Duncan, Your Honor.
Okay, go ahead.
As can be seen in paragraph 34 of the verified complaint, Mr. Hackney moved back into the Fulton County property on March 2nd of this year. And it was stated that he moved out of the house because he was asked to leave or forced out because he was asked to pay rent. If he had rent, he would have probably stayed at the friend's house, but now he's moved back into the Fulton County property. So he either can't pay or he won't pay Ms. Duncan back. And the Supreme Court has approved of such injunctions where potential frozen assets will be needed if the defendant were required to satisfy a judgment for the plaintiff. And that can be seen in what I mentioned before, Kennedy v. W.M. Shepherd Lumber Co. Inc. Second factor, the threat and injury to the moving party outweighs the threat and harm that the injunction may be due to the party being enjoined. And here, Mr. Hackney cannot show that he would be harmed by injunction. He has received in total $615,000, and that is $560,000 from the sale of the Sugar Hill property, which he should have received the entire amount because Ms. Duncan paid for the original $310,000. And then as well, he received the extra $55,000 from the Jonesboro property because, as I said, Ms. Duncan provided $110,000. The property was found out to only be worth half. So he has an extra $55,000 from that for a grand total $615,000. If the harm that they're claiming now, which we saw from their response, is that he needs this money to buy a new home, well, Your Honor, that actually goes to the issue of the money that is being sought they have already shown that they are going to be using for something else, so it won't be there anymore. And he can use the $615,000 that he has from these sales that we know about already. If he doesn't have that money anymore, where did it go? He would receive an unlawful windfall from the Fulton County property sale. For the third prong, Your Honor, there's a substantial likelihood that the moving party will prevail on the merits of the claims. Relevant claims here are money had, money received. That occurs when the parties come to an agreement, not in writing, and one party effectively received an improper windfall based on the payments of the other. And taking the facts of the verified complaint is true, Ms. Duncan is paid for the vast majority, if not all, of the money for the Fulton County property, as well as the investment properties. Mr. Hackney has benefited from all this as an improper windfall, and such as the sale of the Sugar Hill property and the money from the Jonesboro property, and soon to be the sale of the Fulton County property. Unjust enrichment, very similar claim. The difference being here that it's about the value of the benefit provided to one party received by the other, a benefit that defendant equitably ought to be returned or compensated for. And Ms. Duncan's payments for the Fulton County property have conferred residential and possibly financial benefits to Mr. Hackney, and he has provided nothing in return. The fraud claim, Your Honor, that has 5 elements. First
I'm
being
very familiar with the elements of fraud. I deal with it all the time, but please go ahead.
The first element, the false representation. Mr. Hackney falsely represented that any proceeds from the rental income and sale of the investment properties would go first toward paying Ms. Duncan for her contributions and only then share in the remaining profit. That proves true here is Ms. Duncan has not received anything in return. Second element, these actions were intentional, as people do not claim that purchase price of a home is twice the asking price, as Mr. Hackney did for the Jonesboro property. And even if that was a mistake, his refusal to return the funds now is a continuing lie by omission at the very least. The same holds true for the retention of the $560,000 for the Sugar Hill property sale. Third, Mr. Hackney's false promise that he would reimburse Ms. Duncan is what induced her to be the sole financier of these investments to begin with. Fourth, Ms. Duncan's reliance was reasonable because of the confidential relationship that Mr. Hackney and her had, and he was acting as her agent. Speaking about the confidential relationship, and this actually will also go to the claim for breach of fiduciary duties, we provided the court in our brief with a Georgia Court of Appeals case, Tankersley v. Barker. That case is incredibly similar to this case, and just very briefly going over it, that had to do with a plaintiff and a defendant where the plaintiff provided various monetary loans to the defendant who they were going to be married. And the defendant promised that he would, when they would get married, he would use the benefits of the loans to support their relationship. What ended up happening is the defendant never repaid the plaintiff back, despite the fact that the plaintiff's repeated request that he do so. And the Court of Appeals found the parties had a confidential relationship because of their personal relationship and Tankersley's repeated promises that they would marry.
How old is that case?
This case was from 2007, Your Honor.
Okay.
And because of that relationship, Your Honor, the defendant there was a duty to act with the utmost good faith and due diligence before relying on representations. That's the same holds true here. Also, there's an agent relationship, as Mr. Hackney was functioning as an agent for the sale of, or functioning as an agent for the sale of the Fulton County property, but also functioning as an agent for all the other investment properties. And a principal and agent relationship arises whenever one person expressly or by implication authorizes another to act for him or subsequently ratifies the acts of another on its behalf. That can be seen in OCGA 10-6-1. As an agent, Mr. Hackney was required to disclose the actual price of the Jonesboro property, which is only $55,000, the offer that he received for the Fulton County property, and request authorization for accepting that offer, which neither occurred here. And 5, Your Honor, damages. The verified complaint shows, and we've already explained here how damages apply here.
Was there an agent? Was there an agency contract executed between Ms. Duncan and Mr. Hackney?
Not in writing, Your Honor.
Okay.
All the contracts were verbal.
Okay. Okay. Is there, so one basis, I mean, you have two counts for breach of fiduciary duty. One of them seems to be based on this purported agency relationship, right? And
Yes, Your Honor.
Mr. Hackney's superior real estate knowledge as a licensed real estate agent. If I understood correctly, the other one, I think that's count 5. The one we were just discussing is count 6. I think count 5 is based on the nature of their social relationship.
Yes, it's a confidential relationship, Your Honor, and that's from the Tankersley case. And
do you have the site for that Tankersley case?
yes, it is 286 Georgia App 788.
286 Georgia App 788. Thank you.
And again, Your Honor, that one provides a duty, the confidential relationship for Mr. Hackney to act in utmost good faith and relieve her of exercising due diligence before relying upon his representations.
Okay.
And then last, Your Honor, we already covered the brief fiduciary duties for both counts 5 and 6, but speaking very briefly about them. See, only to cover a little bit extra about the agency relationship. Some statutes to discuss about that. OCGA 10-6-1 states that the agency relationship arises one person expressly or by implication authorizes another to act for him or subsequently ratifies the acts of another on his behalf. Code section 10-6-25 states that an agent under common law, such as Mr. Hackney, is prohibited from making any personal profit from his principal's property. For all such, he is bound to account. And then code section 10-6-27 states that the relationship authorizes Ms. Duncan to, quote, follow her money follow the money deposited by an agent in the latter's name and recover the same whenever found. And finally, Your Honor, granting injunction will not disturb the public interest. Georgia law is designed to prevent or at least stop the kind of ongoing intentional, lawful, inexcusable acts that are occurring here. Granting an interlocutory injunction to prevent Mr. Hackney from continuing to harm Ms. Duncan is consistent with that public policy, and which means that the injunction would not disturb the public. Alternatively, Mr. Hackney cannot reasonably claim that enjoining his use of funds obtained solely through Ms. Duncan's resources is a matter of public policy when considering the public as a whole, as precedent demands. That's City of Waycross, 300 Georgia at 113. And like the other 3 factors, this one also weighs strongly in Ms. Duncan's favor.
Okay.
That is all I have, Your Honor.
Thank you, Mr. Pratz. Mr. Piercy?
Thank you, Your Honor. First and foremost, Ms. Duncan has an adequate remedy at law if she thinks she's been wronged. Mr. Hackney has not yet prepared an answer and filed it, but certainly disputes the vast majority of the allegations in that complaint, including that there were agreements to repay money or to provide all the funds from the sale of any property to Miss Duncan. There is one loan that Mr. Hackney took from Miss Duncan for $110,000. We agree on that. The rest of it we contest and dispute, and that's something that the court or a jury is ultimately going to have to determine. These folks, there were significant gifts from Miss Duncan to Mr. Hackney in June of 2023, before Mr. Hackney bought the Fulton County property, and Miss Duncan expressly agreed that when she gifted Mr. Hackney $489,500, that money was to be applied toward the purchase of the Fulton property, and that no repayment of the gift is expected or implied in the form of cash or by future services of the recipient. The parties were very clear while they were dating, before they were engaged, but while they were dating, that these were gifts. It's curious then that Miss Duncan claims that after they broke up, they're even less formal with each other, and that there's no writing that would evidence some agreement that contradicts the gift letters that are attached to our filings as exhibits 1 and 2. Miss Duncan now effectively seeks a security. She wants to be a secured creditor, but the time to become that secured creditor was at or before she made the loans. And the reason that there aren't any documents memorializing these purported loans is because they weren't loans. They were gifts. These parties had a joint bank account for a while they were living together. Both put money into that account. Both took money out of that account. All that's got to be sorted out. But for purposes of today, what Miss Duncan is trying to do is grab the sale proceeds from the Fulton property, which is supposed to sell, I think, on June 16th. And that closing occurs, and if everything goes as it's currently scheduled to go, Mr. Hackney should get about $355,000 in sale proceeds. And that's an important number because it's less than Miss Duncan agreed that she was gifting to Mr. Hackney so that he could purchase the Fulton property, and that she didn't expect to get any money back. If she's right, she can get a judgment and she can collect on it. There is no evidence that Mr. Hackney is going to abscond or that he doesn't have the money to pay. He's carrying a $16,000 a month mortgage. Why would he also want to pay rent somewhere else on top of that? Mr. Hackney is the only person obligated to pay the mortgage on this Fulton property. And he's the only one whose name the property is titled in. If Miss Duncan wanted part of this property, why is she not on the title? She's not. She could have insisted upon that in exchange for this contribution, these gifts. She didn't. The status quo is that Mr. Hackney owns the Fulton property. He is free to keep it, to knock it down, to expand it, to sell it. He can do what he wants with it. It belongs to him. That's the status quo. And she's not
Mr.
on.
Piercy, forgive me.
Yes.
Sorry, for interrupting. But what of Mr. Pratt's representation or characterization argument that the risk of insolvency, right? I understand you would characterize those facts as you've just done, that, why is he going to pay rent if he's got a house to live in or whatever? But what if the court's persuaded that there is some risk of insolvency? Is that enough to create or allow the impoundment of these funds through interlocutory relief?
It's not, particularly because of those gift letters, right? That make it very clear that more than the sale proceeds that are going to come out of that property were given to him with no expectation of payment or future services. None at all. If there was $1 million in sale proceeds, right, and we're above and beyond what she affirmatively gifted to him and swore up and down to banks and everybody else that it was a gift, then maybe they would have an argument. But we're not there. The dollars are less, and that's an important, to my mind, factor here. A decisive factor, and just a desire to collect on a money judgment or worry that a defendant might not have money by the time you get to the end of a case, that's every case I've got. That's every client I represent every single day, all the time. There would be injunction requests for every lawsuit all the time if that were the law. Three emergency hearings in one day would be the norm for the court.
But please don't say that, Mr. Piercy.
I certainly don't want that to be the case. To me, it seems outlandish, right? Like, if she was worried the guy was a credit risk, why all the gifts? Why no contracts? Why no security interests? Why just, yeah, whatever, here you go. We'll work this out later. And that deal is made after they've broken up. There's no confidential relationship anymore. If they've ended their relationship, right? When you're married, you sleep with one eye open. If you're broken up, you got both eyes open, right? She had every opportunity and certainly had notice to have both eyes open, every opportunity to protect herself if she thought there was some issue. Now, we deny that there were any such agreements or arrangements, and that's why there aren't any documents that show it. Your Honor, she has an adequate remedy at law. There's no irreparable harm here. Balancing the equities, right? The parties have been in the position they're in for 9 months, a year. Nobody has raced off to do anything until now. Mr. Hackney doesn't want a $2 million house with a $16,000 a month mortgage. He's looking to downsize. That was something that he did living with Miss Duncan. They're no longer together. He doesn't want to live there anymore. He doesn't want to be saddled with that mortgage. He wants to move on with his life. Like everybody else who's trying to qualify for a mortgage for a new property, he's not running out and buying new cars or obligating his assets or tying them up. He's doing everything he can to be liquid so that the banks are comfortable and he can get his new mortgage and downsize out of this house and move on with his life. If these funds are frozen up, there's a risk that the bank says, you know what? We're not going to fund this mortgage for you. Can I tell you that's what's going to happen? No. I've had this case for 3 days. I've not scrubbed the loan documents. I'm not prepared to opine about what a lender is or isn't going to do. But there's a very real risk that he doesn't get the loan. And then does that put him in breach of his agreement to buy this house? And then does that stick the guy who's trying to sell the house, who had a buyer, who had financing lined up and everything, right? There's sort of a waterfall effect here if Mr. Hackney isn't allowed to take his money and sell his house that's titled solely in his name and pay off the mortgage that he's solely obligated on, and then to take the sale proceeds, which were gifted to him in memorialized in two very formal letters, and to use that money either to make a down payment on a new house or just to stick in the bank because the bank knows that he's supposed to have those funds. For all of those reasons, the injunction request should be denied.
Thank you, Mr. Piercy. Mr. Belenfante?
Thank you, Your Honor. I'll try to be brief, but the issue still before the court is not whether it was a gift or not, and I'll get to that. The issue before the court is not whether or when promises were made. The issue before the court is looking at the equities. Where is the best thing? What is the best thing to do to maintain the status quo where Mr. Hackney does not have the assets, where the house has not sold, and where he has not agreed to purchase another, or at least he has not purchased a secondary home. And I'll get to some of the documents that we got yesterday on that as well. The issue is just, what is the right thing to do with these proceeds? And Ms. Duncan does not have to win all the factors. That's the Waycross decision we cite, but we think certainly she has, or at least at the bare minimum, made a sufficient showing that the risks of allowing Mr. Hackney to gain access to the funds, which he's already said he's going to use them to lock them up into a property, would be significant. The Elyria healthcare decision that Mr. Pratt's decided, I think, puts to bed, the main argument from the other side, which is that there's an adequate remedy at law. There, the Court of Appeals said specifically, it is important to note that it is not enough that there is a remedy of law. It must be plain and adequate, or in other words, as practical and as efficient to the ends of justice and its prompt administration as the remedy in equity. Additionally, if the assets were dissipated because no injunction was granted, any remedy at law would be meaningless. And the very detailed verified complaint demonstrates not only from a historical perspective, but also from a fact of the significant over $600,000 worth of money that Mr. Hackney now has from the sale of the Sugar Hill property and the $110,000 that he admits he owes Ms. Duncan should provide him to do. And so there is, even if she could at some point sue for damages, this is one of those rare cases, and I agree with opposing counsel that in a lot of cases we have clients that ask us to bring an injunction on it too, but we don't do it. But we did do it here because, again, the details in the complaint and the case law that addresses things like this specifically. And it's why we're also asking for limited relief on just the Fulton County property, because that's the one that we know is about to go on sale. In fact, the purchase agreement provided as looks like Exhibit 7 from the defendant shows that the agreement was signed on April 6th. And so the only way Ms. Duncan knew that that property was about to go on sale was because Mr. Hackney's website showed the property as pending sale from that point going forward. I'll get to the gift document issue because I know that's a one that they've spent a fair amount of time on. The gift document was signed in 2023 when the two were in a relationship, and the specific language of the gift document is based on what was the expectation and Ms. Duncan's position at the time it was signed. It is not something that carries on forevermore. But if looking at, and it's, let's see, they're all the same form. So looking at Exhibit 2 of the defendant, number 4, the language is, the funds given to the home buyer were not made available. No, sorry, that's not it. Number 3, no repayment of the gift is expected or implied in the form of cash or future services. Signed June 12, 2023. Looking at the verified complaint, paragraph 33, it is alleged under oath that the agreement changed, that at the time that they broke up, which was in August, I believe, of 2024, Duncan and Hackney entered into an agreement that Hackney would sell the property on their behalf, and all of the proceeds from the sale of the Fulton County property, as well as all appreciation, would go to Duncan, which makes sense given that she was the only one that paid the down payment and the majority of the mortgage payments to allow them to live there.
And to be clear, I know we're at a very preliminary stage, but your
Yes.
representation of that changed agreement is not something that I've got a document supporting currently. Is that right?
No, that's correct. And that's where Tankersley is really important. And Tankersley is really on point because there was not written obligations there. And that's the court said because they were engaged to be married and that the fiance, the male who was the one making all the improper misrepresentations there, continued to say, we're going to get married, everything's fine, I'll support you, etc. It didn't have to be in writing, that a jury could find it, and it was not, at least as a matter of law, required. There's also exceptions, I know, for judgment creditors if, and we cite these cases too, if a document is not in writing, but the proceeds were either procured by fraud, which we allege, but beyond that, if equity warrants returning the funds, then it does not have to be in writing. And there's defenses if they're raised, we can get to on that other point as well. So let's look at just, again, briefly, the irreparable harm here. The argument from Mr. Hackney in his affidavit is that, this is paragraph 7. He's under contract to sell the Fulton County property later this month. I also have a contract to buy another house. Closings are set to occur on the same day. And it could prevent me from purchasing the new house if the money is frozen. That's paragraph 8. The problem is he signed that purchase agreement, which is Exhibit 8, on April 29. That's well after Duncan began demanding repayment, and specifically for the Fulton County property. A verified complaint at paragraph 85 shows that that began at least on or around February 5. Mr. Hackney's exhibit number 3 shows that it continued on February 25. The complaint from paragraphs 85 to 97 run through April 17, where Ms. Duncan is demanding repayment, demanding the house be sold, not because she just wants it to be sold. She's not on the mortgage. It's because she wants the proceeds from it because, as she identifies in those texts that we cite, that her bank account was fully negative. She was having trouble getting cash flow, and her credit cards were maxed out. On April 11, paragraph of the complaint 96, Mr. Hackney made a partial payment of $3,000 after she had explained this desperation and the negative accounts. And then again on April 17, verified complaint, paragraph number 97, she had asked about the status of the Fulton property. So Mr. Hackney went in and put a contract on his new property, also in Fulton County, with all of this knowledge ahead of time, and is now saying that it would be irreparable harm if he could not continue with that plan using Ms. Duncan's money. The further, and I know Mr. Pratt went through some of this, so I won't belabor the point, but if the court just looks at their documents and what we've alleged in the complaint, he netted $560,000 from Sugar Hill because it was $310,000 from Ms. Duncan that allowed them to buy it. Verified complaint, paragraph 50. It sold for $560,000. Verified complaint 53. Jonesboro, where they acknowledge they owe Ms. Duncan $110,000, gets you to a combined total of $670,000 just between what they admit they owe and the proceeds from the Sugar Hill property. The harm, I'll get to that in a second. So, and if you look too at the Exhibit 8, which is the purchase agreement, and they're not paginated, I have it as page 12 of the document, counting the cover Exhibit 8 sheet as the first. It looks like the loan amount is for 75 to 80% of the purchase price. The purchase price is listed on the first page of the document, second page of the PDF at $610,000. That makes the down payment that Mr. Hackney has pledged somewhere between $122,000, which is 20%, or $152,000, which is 25%. Sugar Hill alone pays for both of those. The money he owes Ms. Duncan from the Jonesboro property would have him having to pay an additional $12,000 to $45,000 to keep with the down payment. And if you were to combine the 110 and the Sugar Hill property, he's got $55,000 after buying what he wants to buy in cash. The fact that there has not been the payments, even though there's been agreement, at least on some of it, does show the risk of insolvency. It also shows it kind of hardens that equitable claim. Last on that, Your Honor, in looking at what are the balance of the harms with this all continuing, and again, we'd refer you to the description of the communications about not eating and having, assets insufficient to maintain a positive bank account and maxed out credit cards. If you look at exhibit number 7 from Mr. Hackney again, the earnest money he's put down on this property, this is on page 2, is $6,000. That's what he would lose if he doesn't close. And And that could be paid for by the 110 that he already agrees he owes. So what is the current issue is whether those proceeds should be given to Mr. Hackney when he's acknowledged where they're going to go. He's acknowledged that even those proceeds are insufficient to establish or to satisfy a judgment that Ms. Duncan could get. Again, we're only asking this for a temporary time for at least the court to figure out all these other issues that opposing counsel has raised. The last thing I'll just address is in their brief, they make an argument that there was a delay of Ms. Duncan in bringing this. That's at page 6 of their argument. They say the relationship ended in August of last year, and they had proposed a settlement in March 5 of 2025. The fact that she didn't sign it demonstrates that there are terms in it which were obviously disagreeable. Looking at both those dates, there's an April 11 text I've already talked about, complaint paragraph 96, talking about desperation. April 17 text, verify complaint 97, asking the status of the property. And on April 6 was the first time that there was a contract on the Fulton County home. So there's not been a delay that is inexcusable, certainly not similar to the federal cases cited in their brief. So, Your Honor, I think there are certainly facts that will be disputed, as there are in any of these kind of cases between folks with a former relationship, and there's time to work that out. The question before you now is not who's right or wrong about it. It's just, given particularly Mr. Hackney's own admission that there is insufficient money from the proceeds to satisfy a judgment, should that money be held in the registry of the court or in an escrow until the court does have time to do so?
Thank you, Mr. Bellinfonte.
Thank you.
Okay. First of all, let me thank you all for that very efficient, very focused presentation. I really appreciate it. I've had a chance to look at, as I said, the general outline, the briefing that was submitted by the parties, the petition that was filed. I agree with you that it's all supported by affidavits. I've got exhibits. There's lots and lots of stuff here. And there's lots of meat that will need to long-term be put on the bone of the various causes of action that are asserted by Ms. Duncan. Right now, though, the request here is whether or not to order the essentially impounding, right, of the proceeds of the sale of the property at 2863 Sterling Ridge Court, I think. Is it Sterling Ridge Court? Okay. And here's where I am. Here's where I'm landing. I don't know enough yet. I don't think that the likelihood of success on the merits is particularly compelling here. Not that I don't think that Ms. Duncan might ultimately succeed in demonstrating that, but it's not super compelling. And at the end of the day, while I sympathize with Ms. Duncan and the possibility that there may be an inability to actually recover on any money judgment, what I'm hearing is that this house is not in itself unique. This is ultimately a dispute over money that Ms. Duncan alleges was taken from her. And granted, it went toward the purchase of a home, but ultimately the dispute here is one for damages. And it is nothing about this property other than the imminent sale of it, which will result in proceeds that might satisfy a judgment later. Ultimately, nothing about this property is unique relative to the dispute between the parties. And so all of that is a long way of saying this. As Mr. Bellinfonte correctly pointed out, y'all may persuade me later that I'm entirely wrong in my apprehension of what I believe the facts are currently at this very, very preliminary stage. But what I hear is that this is a dispute about damages, about money damages, and that therefore I believe that, and more to the point, it seems to me that the irreparable harm that has occurred to Ms. Duncan has actually already taken place because she's already been deprived of the property and the money that she either gave or was taken under false pretenses, however one characterizes it, from her by Mr. Hackney. And so for that reason, I do believe that Ms. Duncan has an adequate remedy at law. I also believe that there's not a basis for injunctive relief here as to the proceeds from the sale of that property, because I don't believe that there is a risk of irreparable harm. Because I think the irreparable harm, if it has occurred, has already occurred. And that no order by this court is going to undo that or prevent it from continuing in its existence. Add to that the fact that at least at this preliminary stage, I again don't believe that Ms. Duncan's characterization of the facts is particularly compelling, particularly as it relates to this property. And for those reasons, I don't believe that there is a basis for injunctive relief as to the proceeds of the sale of 2863 Sterling Ridge Court. So that's going to be my ruling. Mr. Piercy, can you please provide me with an order in Word format that I can edit? If you'll email it to Mr. Freehoff, my staff attorney, I will edit it to my satisfaction of how I'm going to rule, and I'll get it on file for you guys.
Yes,
Your Honor, could I just,
Yes.
and take it from, I'll just make the request. Given that there is no contest to at least the 110,000, would the court be willing to have a limited injunction that 110,000 of the proceeds be put into either the registry or an escrow account? Again, just going to the document, the down payment from the proceeds of the sale that Mr. Hackney claims he's going to get about $350-ish in the proceeds of the sale, and the down payment by the documents ranges from 122 to 155,000. Would that be acceptable to the court?
What are your thoughts, Mr. Piercy?
Well, my thoughts are, frankly, we would be happy to pay Miss Duncan $102,000 because he's already paid back $8,000 in July, right after his, and it could be part of a court order. If he doesn't do it, he's in contempt, right? But not to freeze the money before he can secure his mortgage and buy his new house, but after he's secured his new mortgage and has his new house, right? Or if that doesn't happen by July 15, then he's got to pay it anyway. But he's prepared to repay the rest of the $110,000 loan that he took from Miss Duncan, just as soon as we get past the underwriters.
Okay. So I think I interpret that, Mr. Piercy, and to your request, Mr. Belinfante, it sounds like Mr. Piercy, on behalf of his client, wouldn't object to an order requiring the impoundment or repayment directly to Ms. Duncan, so long as it occurs on or after, say, July the 7th, which is the Monday after the 4th of July, something in that range. If Mr. Piercy, on behalf of his client, is willing to agree to that, I certainly could enter an order to that effect if that would satisfy at least part of your client's concerns.
That would help, Your Honor.
Okay.
And again, not as a full release or anything like that. I know,
Right.
I don't think anybody was suggesting that, but just for the record.
Okay. Mr. Piercy, can you include that
I'll do it.
that element? Thank you. Okay. Anything else that the parties need from me other than Mr. Piercy? I will look for your proposed order and I'll get it on file for you as soon as possible. Anything else, Mr. Piercy?
Just the timing of that order. I've got a couple other hearings coming up here in the next little bit. So when are you looking to get that from me?
I mean, nothing crazy, just, realistically within maybe a week. I mean, it sounds as if the parties, things are going to stay. But I don't, the urgency that might be present in some types of cases isn't here. And so I feel like a week is fine.
I can
as
make
long as
that
that's
happen.
doable. Any sooner
make
is
that
fine with
happen.
me as well.
Yes, Your Honor.
Anything else from you, Mr. Belinfante, on this issue?
No, Your Honor.
Okay. I don't know what the status is of service. I would imagine it's probably pretty easy to occur given that we've all got lawyers now and everything. And it sounds as if given the very civil and professional manner in which you attorneys are talking about these issues, that it may be that y'all won't ever need to hear from me again, which would be lovely. But in the interim, I just do want to remind you that at this preliminary stage, once service is secured, if you guys will go ahead and submit a proposed scheduling order, so that I can have you on a calendar and make sure that, you know, y'all have some idea of what, if you're going to engage in discovery, what discovery is going to, how long it's going to take, and when you can be looking at the possibility of a trial. I'll just remind you, I think Mr. Belinfante's been in front of me before on, you know, in my standard practice, but just listen, if y'all need some long period of time to conduct discovery and get to motions, y'all take all the time you need. Y'all know better than I do how much time it's going to take for you to have this case ready to go to trial if it needs to. What I would rather avoid is y'all saying, oh, we need 3 months, or oh, we need 6 months, and then come back to me every 90 days and say, can I have 90 more days? Can I have 90 more days? So
Right.
if you need more time than that, take it. I'm happy to sign an order that gives you the time that you parties feel you need. If you don't need anything else from me, I will look for Mr. Percy's order sometime mid next week, and I'll get it on file for you guys. And I don't believe I put it on the record, but Ms. Hennings, I understood y'all were sharing in the takedown, and so make sure and take care of your court report.
Will do.
Will
Okay.
do.
Thank you, Your Honor.
Thank you,
Thank
Your
you, and
Honor.
again, I apologize for the delay, and I appreciate your patience with me today.